Treatise on Arrest and False Imprisonment. By Charles A. Weismann. A Treatise on Arrest and False Imprisonment. By Charles A. Weismann. Copyright 0 December, 1993 by C. A. Weismann, 2nd edition. Dis 1994, 3rd edition. Nov. 2004. Published by Weismann Publications. P.O. Box 240844, Apple Valley, Minnesota 55124. ISBN 1929205-08-2. Printed in the United States of America. Contents. L. Introduction. 2. Definition of false imprisonment. 3. What constitutes false imprisonment? 3. Length of time required. 5. Damages and liability. 6. Malicious prosecution. 7. 3. Arrest without warrant. 9. The law of the land. 9. Summons. 10. Complaint. 2. Memorandum of law on arrest without warrant. 13. 4. Breach of the peace and felony arrests. 26. What is a arcade of the peace? Arrests for breach of the peace. 27. Threatened breach of the peace. 29. Conditions of felony arrests. 31. S. Defenses to unlawful arrests. 32. Burden of proof. 32. Good faith and probable cause. 34. Ignorance of law. 36. Guilt of painee arrested. 37. Immunity. 38. 6. The use of a warrant in arrest. S. 39. Warrant to be in the possession of the arresting officer. 39. Warrant 10 be shown upon arrest. 43. Invalid and unlawful warrants. 46. 7. Bringing arrested person before a magistrate. 49. Duty of officer. 49. As a trespasser ab initio. 52. Detainment is not a decision of arresting officer. 53. Arrestee ng and releasing without bringing before a magistrate. 56. Defenses. 57. Atels tokenons of fundamental law. 59. Due process neglected. 59. Fourth Amendment argument. 60. Highway traffic laws. 61. Resisting arrest. 64. Handcuffing. 69. Post-arrest booking procedures, fingerprinting, etc. 70. Limitation S upon arrests. 72. 9. Conclusions in Appendix 74. 75.j. I. A Treatise on Arrest and False Imprisonment. By Charles A. Weismann. Copyright 0 December, 1993 by C. A. Weismann, 2nd edition, December, 1994, 30 Dial November, 2004. Published by Weismann Publications. P.O. Box 240844, Apple Valley, Minnesota 55124. ISBN 1-92925-08-2. Printed in The United States of America. Contents. 1. Introduction. 2. Definition of false imprisonment. 3. What constitutes false imprisonment? NTJ. Length of time required. 5. Damages and liability. 6. Malicious prosecution. 7. 3. Arrest with OUT/warrant. 9. The law of the land. 9. Summons. 10. Complaint. 11. Memorandum of law on arrest without warrant. 13. 4. Breach of the peace and felonies. TS 26. What is a breach of the peace? Arrests for breach of the peace. 27. Threatened breach of the peace. 29. Conditions of felony arrests. 31. 5. Defenses to unlawful arrests. 32. Burden of proof. 32. Good faith and probable cause. 34. Ignorance of law. 36. Guilt of party arrested. 37. Immunity. 38. 6. The use of a warrant in arrests. 39. Warrant to be in the possession of the arresting OFFICCR. 39. Warrant to be shown upon arrest. 43. Invalid and unlawful warrants 46. 7. Bringing arrested person before a magistrate 49. Duty of officer 49. As a trespasser ab initio 52. Detainmentee is not a decision of arresting officer 53. Arresting and releasing without bringing before a magistrate 56. Defenses 57. Distortions of fundamental law 59. Due process neglected 59. Fourth Amendment argument 60. Highway traffic law 61. Resisting arrest 64. Handcuffing 69. Post-arrest booking procedures, fingerprinting, etc. 70. Limitations upon arrests 72. 9 Cons and Appendix 74. 2. 1. Introduction. This book is about liberty. It is about the lawful and unlawful means by which government acts in depriving an individual of his liberty. His right teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words: "The contest for ages has been to rescue liberty from RHE grasp o flohi executive power. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrests and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills which turn out thousands of new laws every year. The passion of modern legislatures to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or summons. But it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of these laws. No one can be safe to leave their home or travel about for fear of being subject to thousands of unknown laws in which he could be instantly arrested for transgressing." One law review writer states the problem as follows: "People no longer live their whole lives in the village in which they were born. They pass freely from place to place, and in transit go through innumerable towns and villages. The risk of being arrested on sight, because one's conduct contravenes some regulation which the wisdom of the local solons deems necessary, is appalling to any thinking person. It would be impossible to know at what moment one might become amenable to arrest. A revolution in England and the revolution of the American colonies are said by high authorities to have been largely influenced by promiscuous seizures and searches of persons and property. The history of our ancestors over the centuries teaches that a people cannot be free where the executive power can arbitrarily arrest or imprison citizens, or ransack at will the properties of the people. The executive power is limited and guided by the jaw of the land, or due process of law. If it was a restriction upon the King of England, it must be so for every petty officer today. In many of the treatises on the law pertaining to the rights of citizens, and in many of the older and Banier Crown cases, we find the declaration, the law is very jealous of che liberty aft citizen. What law is it that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his peril. 2. This law also prescribes how arrests are to be made, and the restrictions involved. Unity of Pennsylvania Law Review, Vol. 75, p. 491, April, 1927. 2. Knight. Baker, 117 Oregon 492, 244 Pac. 3. 2. Definition of false imprisonment. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar, Henry de Bracton, 1200–1268, tells us that false imprisonment is one of the oldest violation of rights known. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. 1. False imprisonment is classified as a tort under the common law, and also as a crime. 2. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. In TREATISE practice of the law it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment. Or malicious prosecutions. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on of hands is not necessary to constitute an unlawful detention. For thus the only essential elements of the action are, 1. Detention or restraint against one's will, and 2. The unlawfulness of such detention or restraint. In his treatise on the law/torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint upon a man's freedom of locomotion. 6. Blackstone, in his commentaries on the law, 3 by COMM 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison, or in a private house, or in the sloax, or even by forcibly detaining one in the public streets. 7. SMDS found a line 0/legal liability, vol. 1, p. 12, citing, Bacton's Notebook, vol. 2, p. 314, 1229, pi. 2 Kroegerv. Passmore, 36 Mont 504, 93 Pacific Macbeth v. Campbell, 12S.W.2D 118, 122, Texas 1929. 3 Joseph Chitty, Esq., The Practice of the Law, Vol. I, Chap 2, p. 47, London, 1837. 4 Hammer v. Bieber, 271 MO 326, 197 SW 68, 70, 1917. 5 Sargent v. Watson Brothers Transpco, 244 Iowa 185, 52 N.W.2D 86, 93, 1952, Sinclair Refining Co. v. Meek, 62 GA App. 850, 10S.E.2D 76, 79, 1940, Southern Rico in Kentucky v. Shirley, 121 Kentucky 863, 90 SW 597, 599, 1906. 6 Thomas Cooley, Treatise on the Law/Torts, Vol. 1, 4 Th ed. 109, p.345, Mainz. Huntington, 276 f.245, 248, 1921. 7 Cited by, Fox v. McCuman, 205 Iowa 752, 218 NW 499, 501, 1928, Sargilt v. Watson Brothers Tramp. Co., 244 Iowa 185, 52 N.W.2D 86, 93, 1952. 4. Thus any type of detainment or confinement of a person, or restriction, or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen, or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another, and prevention of his movements from place to place, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. In reviewing several ext book definitions on false imprisonment, the Supreme Court of North Carolina stated, False imprisonment is the unlawful and total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to the class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. Point 9. A rather complete description of what does and does not constitute false imprisonment was given by T.B. Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone or by acts alone, or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All is necessary is that the individual be restrained of his liberty without any sufficient legal cause therefore, and by words or acts which he fears to disregard. Lo. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraints of this nature. 8 Griffin v. Clark, 55 Idaho 364, 42 p. 2d, 291, 301, 1935, citing, Cordelf. Slandered Oil Co., 131 Kansas 221, 289 p. 472, 473. 1930, Loneson v. Tompkins, 13 Federal Ca. 840, 853, no. 9 Rill v. SIOM, 174 NC 588, 94 SE 434, 440, 1917. 10 Garney Ewell. Squires, 62 Kansas 321, 62 Pac.Lu 5, 1006, 1900, Kroegerv. Passmore, 36 MONT 504,93 Pac. False imprisonment has been well defined to be a trespass committed by one man against the pen on of another, by unlawfully arresting him and detaining him without any legal authority. L1. The law sets such a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. 2. All the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. 13. Thus any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie any restraint by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual usually made by an arrest, and physical custody or restraint is not essential to the effectuation of an arrest. So if an officer tells a person that he is under arrest, and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty, and if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered. In such a case there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit. 11 Regood v. High Grade Seed Co., 47 Federal Sup. 12 Giddens 1. Slall, 154 GA 54, 113 SE 386, 388, 1922. 13 McCall, T. R. V. Good, 216 Pat 473, 65 all. 5. Under the belief and impression that submission was necessary, The following definitions will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used the word false seems to be synonymous with unlawful. 1. Any exercise of force, or expressed or implied threat of force, by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant, or a warrant illegally executed. 17. Any restraint, however slight, upon an owner's liberty to come and go as he pleases, constitutes an arrest. Length of time requirement. The tort or wrong of false imprisonment occurs the instance that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before the laurel can be claimed. False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any. 14 Johnson v. Norfolk and W. Rico, 82 West Virginia 692, 97 S.E.189, 191, 1918. 15 Mahan 1. Adams, 144 MD 355, 124 A 901, 904, 1924. 16 Black. It Clarks Greensboro, Inc., 263 NC 226, 139 S.E.2 D 199, 201, 1964. 17 Nose v. Ritchie, 155 SE 127, 128, West Virginia 1930. 18 Turney v. Rhodes, 42 GA App. 104, 155 SE 112, 1930. 6. Time, whereby he is deprived of his personal liberty. 19. Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment. Even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. 20 Where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time duration is not a factor in making an arrest. False imprisonment is defined as an act which, directly or indirectly, is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration. Makes the actor liable. 0. The other. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. 22. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offence at common law, and relief by the party aggrieved was obtained by an action for trespass 6 et armis with force and arms. 23. The illegal arrest of a person without a warrant, or under an invalid warrant, entitles him to compensation for the damages sustained by reason of the false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did in Murphiv. Countess, 1 Har. Del. 143, in an action for trespass, assault and battery, and false imprisonment, the court held that the plaintiff could recover, not merely for the time TB constable was bringing him to jail, but for the whole period of his imprisonment. And in Mandeville v. Guernsey, 51 Barb, NY, 99, the court said, the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which result directly from the wrongful act. Unlawful interference with or injuries to the liberty of a citizen is a violation of his natural, inherent, and absolute rights, which damage results as a legal consequence. 19 SJNC Erigen, NGCO. V. Meek, 62 GA App. 850, to SE 76,79, 1940, citing, 3 by Commander 127, 12 AMER and, ENG Encyclopedia O/Law, 72-1, 19 Psych.319. 25 American Jurisprudence, 2D, Arrest, T1, p. 696. 21 Sergeant v. Watson Brothers Transpco, 244 Iowa 185, 52 N.W.2 D86, 92, 1952. 22 Cornish. YSLALE, 215 MD. 64, 137 ATI.2 D 170, 173, 1957. 23 Megents v. Huntington, 276 Federal 245, 249, 1921, citing, 3 Blackstone, Commander 127, 4 Black Sloan, Com. 24 Knickerbocker Steamboat County v. Cusack, 172 Fed. 25 Mines v. Huntington, 276 Federal 245, 248, 1921, citing, Adler v. Fenton, 24 Howe, 65 U.S. 407, 410, 1860. A false imprisonment generally includes an assault and battery, and always, at least, a technical assault. 26 An unlawful arrest, imprisonment, and prosecution of a person can cause T-bar person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress, or anguish. Humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. Upon the subject of damages, the law specifies FWO kinds of damages or divides them into 2 classes. There are what are called actual damages, then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are also called compensatory damages as they compensate the injured party for the actual injuries sustained, and no more. Punitive damages are those that grow out of the wantonness or atrocity, or aggravated by the act. They are the injuries and sufferings that were intended, or occurred through. 7. Malice, carelessness, or negligence amounting to a wrong so reckless and wanton as to be without excuse. 27 These are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for the damage caused. Thus, where a man was illegally arrested by a police officer, and was placed in a patrol wagon in which he was taken to the central station, it was held that the 2 officers in charge of the patrol wagon were liable, along with the arresting officer, for false imprisonment. Malicious prosecution. In many cases of imprisonment or wrongful arrests, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the 2 charges are not interchangeable or synonymous. There is a fundamental difference between these 2 charges. They are made up of different elements, enforced by different forms of action, are governed by different rules of pleading, evidence, and damages, and are subject to different defenses. 29 One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicto for the recovery of damages which have proximately resulted to person, property, or reputation from a previous unsuccessful civil or criminal proceeding, which was prosecuted without probable cause and. 26 Black. Clark's Crunsborough, Inc., 263 NC 226, 139 S.E.2D 199201, 1964. It has been said that, an illegal arrest is an assault and battery, SLA UI. Robinson, 145 MC 77, N. A. 2D, 260, 262, 1950. 27 Ross. Leggett, 61 Michigan 445, 28 NW 695, 697, 1886. 28 Cook. Hoslings, ISO Michigan 289, 114 NW 71, N, 1907. 29 Snyder I. Thompson, 134 Iowa 725,112 NW 239, 241, 1907, 35 CJS, False Imprisonment, 4, p. 625. 8. With malice. In an action of this type the burden residential ts upon the plaintiff, the ONC bringing the suit, to establish each and all of the following proposition s before being entitled to recover, to wit. 1. He was prosecuted in a criminal proceeding or civil suit. 2. Defendant instigated such prosecution. 3. The prosecution term in ad ed favorable to the accused. 4. Defendant acted without probable cause. 5. Defendant acted with malice, and 6. Damages that were caused. 30. In Indiana a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail, and without any charge preferred against him. The defendants insisted his complaint was bad as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There is a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial, without legal process, it is false imprisonment. LL. An arrest or imprisonment can be malicious or false, but not both. In a case of malicious prosecution the arrest or detention is procured from malicious motives and with improbable cause, but was done under lawful process, whereas in false imprisonment the detention is without proper legal authority. 32. One may be legally arrested for some alleged reason, but done maliciously. If he is found to be not guilty he then has a case for malicious prosecution but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not he has a case for false imprisonment but not malicious prosecution. If this is done with malice it would add punitive damages to lawsuit. In describing the distinction between these two charges, the Supreme Court of Oregon stated that foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. In other words, the want of authority is an essential element in an action for false imprisonment, whereas malice and want of probable cause are the essentials in an action for malicious prosecution. Somewhat different to the wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose, in which malice or ill will may also be a factor. The term malicious arrest is used in some cases instead of malicious prosecution, but the latter is broader in scope. 30 SRG NL1. Wellsoil Brothers TRRLLLS Pico, 244 Iowa 185, 52 N.W.2 D86, 91, 1952, Cox 1. Cascio, 96 So.2 D 872,874, 1957. 3 tons Kilo RL. Lotra ND Others, 35 IND 285, 286-87, 9 AM Republic 735, 1871. 32 Stalling SI. Fost R, 119 cal.app.2d 614, 259p.2d 1006, 1009, 1953. 33 Stat I. Williams, 45 Oregon 314, 77 Pac. 34 RORTSV. Thomas, 135 Kentucky 63, 121 SW 961, 962, 1909. 9. 3. Arrest without warrant. The law of the land. The authority to arrest without warrant was rather limited and well defined at common law. A law which has been made part of our constitutional law in the due process provisions. The common law rule on arrests is based on experience and common sense. As a general rule at common law, an arrest could not be made without a warrant. Thus the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter, in delivering an opinion for the Supreme Court of Michigan, as follows. The law governing this case is elementary. Except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without a warrant. The objective in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrests had to yield to the liberty of the citizen. The liberty of citizens is too sacred to be left to the arbitrary will of men. I. Cook v. Hastings, 150 Michigan 289, 114 NW 71. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obvious and well known. Therefore everyone's liberty was safe since all knew for what reason they could or could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact? Or if the law on arrests can be changed by statutes? By the Due Process Clause, the common law governs what the law on arrest is in this land, and where it exists the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint, which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. 10. State of Minnesota. County of Hennepin. Charles A. Weissman, Plaintiff. vs. Mark L. Fawning, Defendant. 2. Defendant above named. District Court. 4th Judicial District. Court File No. Summons. You are hereby summoned and required to serve upon the plaintiff an answer to the complaint which is herewith served upon you within 20 days after service of this summons upon YOLL, exclusive of the day of such service. If you fail to do S0, judgment by default will be taken against you for the relief requested in the complaint. Dated, August 23, 1993. Charles A. Weissman, Plaintiff 11751 West River Hills Drive No. I-070 Burnsville, Minnesota. State of Minnesota. County of Hennepin. Charles A. Weissman, Plaintiff. vs. Mark L. Fawning, Defendant. 2. District Court. 4th Judicial District. Court File No. Complaint. Plaintiff for his complaint against defendant states and alleges. 1. On September 30, 1992, plaintiff was traveling in his automobile on a public highway called 135W between Richfield and Minneapolis, going northbound when stopped by the defendant acting as a highway patrolman, an employee of the state of Minnesota. 2. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. The defendant insisted that plaintiff must have the said license. 3. The defendant then arrested, searched, and handcuffed the plaintiff, without warrant, and over his objections that defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. 4. The defendant gave no specific charges to the plaintiff, or his being stopped or for the arrest, nor did he advise him of his rights, as shown in the defendant's field report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to the Hennepin County Jail where the defendant knew that the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement, or an indefinite period of time, and possibly be subject to other types of assaults and batteries. 6. Further, the plaintiff, by his own admission, made no attempt to bring the defendant before a magistrate or judge, when he had full opportunity to do so, being that the arrest occurred about 10:15 a.m. on a Wednesday. 7. The defendant, acting on his own accord, and without warrant or court order, had the plaintiff's automobile towed to an impound lot, and put it on a hold order. 12. Count I. False imprisonment. 8. Plaintiff re-alleges paragraphs 1 through 7. 9. On September 30, 1992, the defendant, without warrant or due process of law, Minnesota Constant, Art 1, Sector 7, unlawfully arrested the plaintiff, and acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. As a result of the defendant's false imprisonment of the plaintiff had his right to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend a scheduled meeting. Count 11. False imprisonment. Plaintiff FE alleges paragraphs 1 through 7. The defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and, by his own admission, made no attempt to bring the plaintiff before a proper judge or court as is required by due process. The acts of the defendant in deciding how to deal with the plaintiff after his arrest, and failing to take him to a judge or court to so decide, constitute false imprisonment by the defendant under the Lawful Arrest, Minnesota Constant, Art 1, Seconds. Count 3. Assault and battery. Plaintiff re-alleges paragraphs 1 through 7. Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprinting and booking procedures, and harassment. Therefore, plaintiff demands judgment against defendant, as his liability appears, in the sum of $10,000, $1.0,000, together with the costs and disbursements. Dated, June 24. Charles A. Weissman, Plaintiff 1175 IW River Hills Drive No. 107D Burnsville, Minnesota. 13. State of Minnesota. District Court. County of Hennepin. Charles A. Weissman, Plaintiff. V.S. Mark L. Fawning, Defendant. Fourth Judicial District. Case No. Memorandum of Law on Arrest Without Warrant. Comes now the plaintiff, Charles A. Weissman, a free citizen of the state of Minnesota, who respectfully presents and submits this memorandum as evidence and proof of the prevailing and controlling law regarding the matter now before the court. Arguments and statements of law. The defendant claims that his arrest of the plaintiff without warrant for the violation of 2 traffic laws was lawful. Defendant claims that he is authorized by statute to make arrests for any violation of laws of the state whether they are a misdemeanor or a felony when committed in his presence. The facts of this case lead to the conclusion of law that the defendant did not have any lawful authority to arrest the plaintiff. The defendant had no warrant for the arrest of the plaintiff, and he alleges that he only saw plaintiff commit a misdemeanor, i.e., a traffic violation. There was no claim of a felony committed or of a breach of peace committed. At common law, and under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the plaintiff of his liberty by an act not pursuant to due process of law, the arrest is unlawful. Due process is not determined by the legislature. Il is manifest it was not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive and judicial powers of government, and cannot be so construed as to leave. Page I of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 14. Congress free to make any process due process of law, by its or near will. Murray's Lessee v. Hoboken IMP Co., 18 How. 59 U.S. 272,276, 1855. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. Minnesota Cons. Art 1, Secretary. The words due process do not mean anything which the legislature may see fit to declare to be due process of law. Slate XREI. V. Billings, 55 Minnesota 466, 474, 1893. Due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guarantee that government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held at common law, and was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designate as due process of law. 6 RCL Cons. Law. 435. The Constitution guarantees these pre-existing rights and procedures in the due process provision. What is due process of law may be ascertained by an examination of those sold usages and modes of proceedings existing in the common and stirred law of any land before the emigration of our ancestors. Twining v. New Jersey, 211 U.S. 78, 100, 1908. The expressions due process of law and law of me land have me same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers, as it existed and was understood and administered when that instrument was framed and adopted. State v. Doheny, 60 Main 504. In interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Eckern v. McGovern, 154 Wisconsin 157, 142 NW 595, 620, 1913. Thus the mode of arrest by which one can be deprived of his liberty is to be determined by the pre-existing common law principles and modes of procedure. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature. The common law drew a distinction between an arrest for misdemeanors, such as that which the defendant arrested the plaintiff upon, and arrests for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless it constituted a breach of the peace. The misdemeanor traffic violation was not a breach of peace, and thus the defendant needed a warrant to make an arrest for such offense. In determining the law surrounding arrests, the Supreme Court of South Carolina, in the case of Slow v. Byrd, 72S.C.104, 51 S.E. 542, 544, 1905, affirmed a PRI or DICOD of the court, holding that page 2 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. At common law, as a general rule, an arrest could not be made without warrant for an offense less than felony, except for a breach of the peace. 3 Sci. 880, State v. Sims. 16 SC 486. 15. The fact that the defendant believed that the plaintiff committed a misdemeanor and had charged him with a violation of the traffic law, did not authorize him to arrest the plaintiff. In a New York case, the state Supreme Court held that a city alderman or justice of the peace could not, at common law, arrest or cause an arrest for a misdemeanor not amounting to a breach of the peace, without warrant, though happening in his presence. The Supreme Court, in the case of Butolph v. Blust, 5 Lansing's Republic 84, 86, 1871, stated, at common law an arrest could not be made of a person charged with a misdemeanor except on warrant of a magistrate, unless it involved a breach of the peace, in which case the offender might be arrested by any person present at its commission. 1 Chitty, Criminal Law, 15, Carpenter v. Mills 29 How. Pro R 473. In the very well-reasoned and authoritative case of Expart Roads, 202 Ala 68, 79 So. 462, 464, 1918, the Supreme Court of Alabama related the due process provision to the Act of Arrests. It asserted that any seizure or arrest of a citizen is not reasonable, or due process, merely because a legislature has attempted to authorize it. These phrases are limitations upon the power of TB legislature, as well as upon TBAT of the other departments of government, or their officers. In determining what was due process regarding arrests, the court stated, it must not be forgotten that there can be no arrest without due process of law. An arrest without warrant has never been lawful, except in those cases where the public security requires it, and this has only been recognized in felony, and in breaches of the peace committed in the presence of the officer. Expare Roads. 202 Ala 68, 79 So. 462,465, Seiling, Sarah Way's case, 41 Michigan 304, INW 1023, 1879, ETL. Also cited and affirmed in Pinkerton v. Verberg. 78 Michigan 573, 44 NW 579, 583, 1889. State v. Williams. 45 Oregon 314, 77 Pacific 965, 969, 1904, Adair v. Williams. 24 Arizona. 422, 210 Pac. The Alabama Supreme Court in the Rhodes case went on to say that the phrase due process must be determined by what it meant at the common law, and when the Constitution was adopted, p. The court then cites the case of Tillman v. Beard, 121 Michigan 475, 80 NW 248, 1899, in stating, officers are justified in arresting without warrant only in cases of felony and breaches of the peace. This is elementary. It is needless to cite authorities. At one time in the history of American law and jurisprudence, the concept that no one could be arrested for a misdemeanor except with a proper warrant was so basic and elementary that it was not necessary to give any authorities to prove it. Yet this basic concept was found to be too restrictive to the ever-growing oppressive government that has gained power in this country. Thus, in order for it to control the page 3 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 16. Liberty of citizens, and to enforce its oppressive laws, the corrupt, de facto government has gradually undermined a very basic principle of constitutional law. In the Pinkerton case, supra, it was held that a police officer could not arrest a woman, without a warrant, upon mere suspicion that she was upon the street for the purpose of prostitution. Even under provisions of the city ordinance allowing such arrests, the fact that she bad a reputation of being a street walker, and that the officer knew of her reputation and believed she was plying her vocation as such, plus the fact she did not give her name to the officer stating it was none of his business, and that she dared the officer to arrest her, did not give the officer grounds to arrest her. The court said, if persons can be restrained of their liberty, and assaulted and imprisoned, under such circumstances, without complaint or warrant, then there is no limit to the power of a police officer. Any law which would place the keeping and safe conduct of another in the hands of even a conservator of the peace, unless for some breach of the peace committed in his presence, or upon suspicion of felony, would be most oppressive and unjust, and destroy all the rights which our Constitution guarantees. These are which existed long before our Constitution, and we have taken just pride in their maintenance, making them a part of the fundamental law of the land. Pinkerton v. Verberg, 78 Michigan 573.44 NW 579. 582-83, 1889, Larson v. Feenry. 196 Michigan I. 162 NW 275. Under the topic of arrest as found in Volume 2 of Ruling Case Law, we find the heading, Constitutional Requirements as to Warrants, wherein it states: Fundamental constitutional guarantees of personal liberty protect private individuals in the right of enjoyment of personal freedom without unlawful restraint. And it is universally recognized that no one may be arrested except by due process of law. 2 RCL 463. Here again we find this principle of arrest only by due process of law was once universally recognized, yet the defendant has ignored such process in his arrest of the plaintiff. The law regarding warrantless arrests was also declared by the Supreme Court of Wisconsin in the case of Radlov. National Food Slurs, Inc., 20 Wisconsin 2D 224. 121 N.W.2D 865. 867, 1963, as follows. In Stitgen v. Rundle. 1898, 99 Wisconsin 78,80, 74 NW. 536, this court established the principle that an arrest without warrant has never been lawful except in those cases where the public security requires it, and this has only been recognized in felony and in breaches of the peace committed in the presence of the officer. This rule was reaffirmed in Gunderson v. Stubing, 1905, 125 Wisconsin 173, 104 NW 149, 1 American Law Reports. Annotated, 585. The Radloff case involved a shoplifter who was stopped and arrested by store employees for taking 2 cartons of cigarettes. The state Supreme Court said that the employees had the right to stop the shoplifter and recover the goods he had stolen from their employer, and were not negligent per se in so doing. However, since the page 4 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 17. Taking of the cigarettes constituted a misdemeanor, the store employees had no right 10. Arrest the shoplifter when they had no warrant to arrest. In the Gunderson case, the court explained that arrests without warrants were allowed at common law only where the ends of justice would be defeated without it, and that it must be confined to cases of strict public necessity. Where a person was arrested without warrant and charged with public drunkenness, which resulted in charges of resisting arrest. It was held by the Supreme Court of North Carolina that the arrest was illegal as the state failed to make a prima facie case by showing that the defendant's conduct at the time of arrest amounted to either an actual or threatened breach of peace. The court said it is manifest that mere drunkenness unaccompanied by language or conduct which creates public disorder amounting to a breach of the peace, will not justify arrest without a warrant, and that not every misdemeanor is a breach of peace. In a very well-reasoned decision on the subject of arrests, the court held the following. It has always been the general rule of the common law that ordinarily an arrest should not be made without warrant and that, subject to well-defined exceptions, an arrest without warrant is deemed unlawful. 4 by COMM 289 ETSEQ, 6 CJS, arrest. p. 579. This fecundation principle of the common law, designed and intended to protect the people against the abuses of arbitrary arrests, is of ancient origin. It derives from assurances of Magna Carta and harmonizes with the spirit of our constitutional precepts that the people should be secure in their persons. Nevertheless, to this general rule that no man should be taken into custody of the law without the sanction of a warrant or other judicial authority, the processes of the early English common law, in deference to the requirements of public security, worked out a number of exceptions. These exceptions related in the main to cases involving felonies and suspected felonies and to breaches of the peace, authorities cited. Slate /I Mobley, 240 NC 476, 83 S.E.2 D 100, 102, 1954. The overall opinion of the court stressed the principle of the common law as controlling in arrests, thus characterizing as erroneous the view that any offense in the presence of an officer is arrestable without warrant. In Texas it was held that an arrest without a warrant, for selling in the officer's presence a railroad ticket in violation of a city ordinance prohibiting the selling of such tickets, was unlawful, as the offense charged was not a felony, nor an offense against the public peace. MKNT Rico v. Warner, 19 Texas Civ App. Sheriffs, constables, and other officers under the executive branch of government had always been recognized as having authority to arrest for felonies committed and for misdemeanors amounting to a breach of peace. But this is the extent of their power to arrest without a warrant, and this constitutional principle is well grounded in ancient common law safeguards of individual liberty. Page 5 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 18. In England, under the common law, sheriffs, justices of the peace, coroners, constables, and watchmen were entrusted with special powers as conservators of the peace, with authority to arrest felons and persons reasonably suspected of being felons. Conservators of the peace also had the authority to make arrests without warrants in case of a misdemeanor which involved a breach of the peace committed in the presence of the officer making the arrest. 2 Ruling Case Law, p. 446, Orrick v. State. 105 So. 465, 469, Miss. 1925, Graham v. Stair, 143 GA 440, 85 SC 328, 330. 1915, Kennedy v. Seor, 139 Miss 579, 104 So. 449, 450, 1925, Wilson v. Town O.J. Mooresville, 222 NC 283, 22 S.W.2 D 907, 911, 1942, People v. McGurn, 341 ill. 632, 173 NE 754, 756, 1930. It has been held that constitutional provisions of rights are to be interpreted according to the common and statute law of England prior to the emigration of our ancestors, and by the law established here before the Constitution was adopted. Under the common law the powers of state agents were limited and the requirements for an arrest warrant was strictly enforced. United States v. Tarlowski, 305 F. Sup. This procedure for arrest is part of the due process of law provision of the Constitution which protects citizens from the arbitrary infringement of their right to personal liberty. Thus, any specific authority for arrests must be based upon the common law procedures that allowed a deprivation of one's liberty. This was so held by the Supreme Court of Michigan as follows. It has already been decided that no arrest can be lawfully made without warrant, except in the cases existing at common law before our Constitution was adopted. People v. Swift, 59 Michigan 529, 26 NW 694, 698, 1886. Since liberty cannot be deprived except by the law of the land, or due process of law, no statute or ordinance can constitutionally be enacted which allows arrests without a warrant for any purpose the legislature decides. Due process is a limitation upon the legislature, and thus a legislative statute cannot be the due process by which one can be deprived of his liberty by arrests. In a legal article titled, Arrest with and Without a Warrant, written in the University of Pennsylvania Law Review, Volume 75, No. 6, April, 1927, p. 485, numerous authorities were cited in support of the following proposition. It is usually said that not even a peace officer is privileged to make an arrest without a warrant for a misdemeanor which does not amount to a breach of the peace. And there are many cases which expressly deny the privilege to arrest for such a misdemeanor, p. 486. In the annotation of TB American Law Reports, Vol. 1, p. 585, is found a legal study titled, Constitutionality of Statute or Ordinance Authorizing an Arrest Without a Warrant, in which the following is stated. 11 has been stated that in cases less than a felony an arrest could only be made without warrant, where there was a breach of peace in the presence of the person arresting. Cases cited. Page 6 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. The limits to the power of arrest by a constable, without process, was well defined at common law. To prevent the escape of a felon, he had authority to arrest anyone whom he reasonably suspected to have been engaged in the perpetration of a felony. To prevent breaches of the peace, he had the right to arrest any person who was engaged in, or in his presence threatened to engage in, an affray or other breach of the peace. Beyond this, the law did not allow him to exercise the function of determining whether there was a sufficient case of the violation of a law to justify an arrest. Read, J., in Newark v. Murphy, 1878, 40 NLL 145. 19. After this excerpt, the law report stated that the foregoing statement from Newark v. Murphy is in accord with the weight of American opinion. Those cases which seem to deviate from this proposition are those which have upheld arrests for certain acts that were unlawful at common law, such as streetwalkers. In Tiedemann's Treatise on the Limitations of Police Power, 1886, 33, is found the requirements for a lawful arrest and the exceptions to a warrantless arrest. What constitutes a lawful arrest? As a general proposition, no one can make a lawful arrest for a crime, except an officer who has a warrant issued by a court or magistrate having the competent authority. 3.3a Arrests without a warrant. Although it is the general rule of law that there can be no arrest without a warrant of the nature just described, yet there are cases in which the requirement of a warrant would so obstruct the effectual enforcement of the laws that the ends of justice would be defeated. For public reasons, therefore, in a few cases the personal security of the citizen is subjected to the further liability of being arrested by a police officer or private individual without warrant. But the right thus to arrest without a warrant must be confined to the cases of strict public necessity. The cases are few in number, and may be stated as follows. L. When a felony is being committed, an arrest may be made with a warrant to prevent any further violation of the law. 2. When the felony has been committed, and the officer or private individual is justified, by the facts within his knowledge, in believing that the person arrested has committed the crime. 3. All breaches of the peace, in assaults and batteries, affrays, rims, etc., for the purpose of restoring order immediately. The rule of the common law, that a peace officer or a private citizen may arrest a felon without a warrant, or on view a breach of the peace, has never been extended to any and all misdemeanors. While there have been some erroneous decisions that have recognized statutes authorizing arrests for misdemeanors that do not constitute a breach of the peace, none are based upon the meaning of due process of law. Thus arrests are not lawful where only a misdemeanor occurs unless it is of the nature of a breach of peace. At the common law an officer had no authority to make an arrest for a misdemeanor though committed in his presence unless it involved a breach of the peace. *****. Page 7 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 20. Right of personal liberty is a very high prerogative right, and to deprive one of that right, without due process flaw. We must find specific authority for doing so. It cannot be left to inference or some strained construction of statute or ordinance. State v. Lutz, 85 West Virginia 330, 101 SC 434, 43, 1919. The specific authority for arrests is grounded in the ancient settled maxims of law, which no statute can abrogate without violating the due process of law provision of the Constitution. Thus a warrant must be obtained for a misdemeanor that is not a breach of peace. The Supreme Court of Minnesota has stated on several occasions that even in the case of a felony an arrest and search should not be made without a warrant unless there is a compelling necessity to do so. Slow v. Mast Ryan, 285 Minnesota 51, 57, 1969. TB Supreme Court of Rhode Island in declaring the requirements at common law for an arrest stated that law permitted an officer to arrest without a warrant on reasonable suspicion based on his knowledge that a felony had been committed. In all other cases, except in the case of a misdemeanor amounting to a breach of the peace committed in his presence, an officer had no authority, at common law, to arrest without a warrant. Authorities cited: Kaminsky v. Durand, 64 RJ 387, 12 Atlantic 2D 652, 654, 1940. In American Jurisprudence, 2D, Volume 5, under the subject of arrest, Sections 26 and 28, pages 716, 718, it states: at common law, a peace officer cannot arrest without warrant for a misdemeanor, although committed in his presence, unless a breach of peace is involved. At common law, the right to arrest for a misdemeanor committed in the presence of the officer is limited to those offenses which amount to a breach of the peace. The basis for the rule is that arrest without warrant is permitted, in cases less than felony. Not for the apprehension of the offender, but only for the immediate preservation of the public peace, and, accordingly, when the public peace is not menaced, a warrant is necessary. Authorities cited, see also Section 22. In Corpus Juris Secundum, Volume 6a, under the subject of arrest, and under the heading of arrest or detention without warrant 10, p. 17, it is written: at common law, however, it has always been the rule that, except in cases where the public security has demanded it, arrest without a warrant is deemed to be unlawful. Due process of law, which declares that no citizen shall be deprived of any of his rights of life, liberty, or property, unless by the law of the land, or the judgment of his peers, Minnesota Const. Art. I, Sector 2 and 7, is the controlling factor in the matter of the arrest made by the defendant. An arrest is a deprivation of one's liberty, and the due process that must be followed in an arrest is that process which existed at common law. To prevent the exercise of arbitrary power at the discretion of government, it was deemed wise to secure the principles already sold in the common law upon this vital point of civil liberty in written constitutions, Cooley, Const. Lim 364 and Notes. Page 8 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 21. Where a Chicago policeman arrested a man for vagrancy, the officer was found guilty by a jury of false imprisonment. The Supreme Court of Illinois upheld the conviction of the policeman and declared the rule of law regarding arrests without warrants. Blackstone says, the constable hath great original and inherent authority with regard to arrests. He may, without warrant, arrest anyone for a breach of the peace committed in his view, and carry him before a justice of the peace, and in case of felony actually committed, or a dangerous wounding whereby felony is likely to ensue, he may, upon probable suspicion, arrest the felon, and, for that purpose, is authorized, as upon a justice's warrant, to break open doors, and even to kill the felon, if he cannot otherwise be taken. For by canoeing. In all other cases, however, the authorities are uniform. A constable or policeman has no authority to make an arrest without a warrant, Amhorides cited, Shanley v. Wells. In a case for false imprisonment, the Supreme Court of Maine examined the law regarding arrests and held, the principles which, by the common law, regulate the right to arrest, or cause an arrest, without warrant, have been long settled both in this country and England, and, by these principles, the rights of these parties must be determined. After citing numerous cases involving the authority to arrest, the court stated: in many of these cases it seems to have been held that the authority of an officer to arrest for misdemeanor, without warrant, is limited to breaches of the peace or affrays, committed in his presence. Palmer v. Maine Cent Arco, 42 Atlantic 800, 803, 92 Me. 399, 1899. In a case involving a state liquor prohibition law, a man, while walking down along a public street, was accosted by a police officer, and asked if he had any liquor on his person. He replied that he did. Thereupon the officer searched him and found a pint bottle of liquor in his inside coat pocket. He was then taken to the police station. The State Supreme Court of Wisconsin said that when the police office stopped the man, he was illegally arrested and was illegally searched, as he had due warrant to do either. The court said that it is a serious thing to arrest a citizen, and it is a more serious thing to search his person, and it must be done in conformity to the laws of the land. Regarding the law on arrests, it held: at common law, arrests for misdemeanors were not permissible without a warrant except for acts committed in the presence of the officer causing a breach of the peace. Allen v. Slough, 183 Wisconsin 323, 197 NW 808, 8/0, 811, 1924. Thus, in order that the citizen's sacred right of liberty be secure and preserved, it has always been fundamental law that arrests without warrant were not deemed lawful. With only a few well-established exceptions of felonies and breaches of peace, the liberty of citizens would never be safe if such principles could be determined, and thus. Page 9 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 22. Abrogated by statute. Therefore, these principles surrounding arrests are regarded as fundamental law under our American system of government, as held by the Supreme Court of Michigan. Under OUF system, we have repeatedly decided, in accordance with constitutional principles as construed every white air, hat no arrest can be made without warrant except in cases of felony. OC in cases of breaches of the peace COMM and in the presence of the arresting officer. This exception, in cases of breaches of the peace, has only been allowed by reason of the immediate danger to the safety of the community against crimes of violence. Yerkes v. Smith, 157 Michigan 122 NW 223, 224, 1909, citing, Robeson v. Minor. 68 Michigan 37 NW 21. In the Yerkes case, it was held that the playing of baseball on Sunday did not necessarily involve a breach of peace justifying an arrest, though it may cause a breach of peace. The Court said that before a summary arrest can be made for a breach of the peace, not only must overt acts be committed in the presence of the officer, but they must be violent and dangerous acts of some sort. In the Robeson case, the court held that a liquor law ordinance which allowed arrests without process was unconstitutional because it was not pursuant to due process of law. Where a man was arrested for public drunkenness, the question arose whether this was an offense for which one could be arrested without a warrant. The Supreme Court of Appeals of Virginia declared the law on arrests. Fhi common law unto arrest is the law on that subject in Virginia. At common law, a peace officer may arrest without a warrant for a breach of the peace committed in his presence, but for no other misdemeanor. Gallagher v. Commonwealth, 161 VA. 170 SC 734. Authorities cited. The common law on arrest is the same in every state, as due process of law has the same meaning through OUT America. The security of the citizen's liberty in this country is to be more highly regarded than it was in England under the common law. To say it is less regarded is to make a mockery of the Revolution. In a New Jersey case, a man was arrested by two city policemen on orders of their superior to do so, alleging that he was guilty of disorderly conduct, and was taken to a police station and held overnight. This was done without any charge or complaint made against the man and without any warrant. The only authority for the arrest was that the officers were told to do so. In a suit for false imprisonment, it was held by the Supreme Court of New Jersey that the arrest was without authority and gave the following opinion. The legal principle underlying this case and the one to be applied to lawfulness is firmly embodied in the rules of the common law, which has been handed down to us from early times unimpaired, in its full vigor. For the protection of personal liberty, against illegal arrests. The liberty of the person is too important a matter to the state to be interfered with without the safeguards with which the law guards such invasions. This court has. Page 10 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. Said, the limits to the power of arrest by a constable, without process, was well defined at common law. The regard for liberty of the person was so great that the common law did not confer upon a mere conservator of the peace the power to touch the person of the subject, of his own volition. Except in those cases when the interests of the public absolutely demanded it. Collins v. Cody, 95 N.1. Law 65, 113 Atlantic 709, 710, I-920. 23. In a Pennsylvania case, a woman was arrested for causing and procuring to be made, loud and annoying sounds and noises at late hours of the night, in a certain tent near a city street, by beating upon a drum. Upon indictment, her counsel moved that the indictment be quashed as she was arrested without affidavit and warrant while she was in a tent upon private property. It was held that the arrest was unlawful as the act was such that summary arrest was not justified and due process required a warrant for such arrest. It is the undoubted right of every person in this community not to be deprived of liberty without due process of law, and if the defendant has been arrested without due process of law, the indictment against her cannot be sustained. It has long been recognized that arrests without warrant are justified in cases of treason, felony, or breach of the peace, in which a cruel or threatened violence is an essential element. I. Hales PC. 589, 2 Hawkins PC, ch 13, Sector 8, 1 Burns, 1, 287, 4 Blackstone, 292, 9 Bacon, Abrid 468, 1 Chitty Cr Law. 15. Clark's Criminal Procedure, 39, Russell, Crimes, Vol. 3, page 83, For America and ENG Encyclopedia of Law, 902. Commonwealth v. Quebec, 8 Penn Dist Republic 521, 522, 1899. It must be remembered that, not every misdemeanor involves a breach of the peace. Commonwealth v. Gorman, 192 NE 618, 620. Under the common law, acts that were malum per se, that is wrong or unlawful by their nature, were often felonies or breaches of the peace, and subject to arrest without warrant. But that is not the law for an act that was only malum prohibitum, being made unlawful only by statute, and without such enactment were otherwise innocent acts. The law asserts that for such statutory misdemeanors, not amounting to a breach of the peace, there is no authority. 3. An officer to arrest without a warrant. As a general principle, no person can be arrested or taken into custody without warrant. But if a felony, or a breach of the peace, has, in fact, been committed by the person arrested, the arrest may be justified. Burns v. Urban, 40 NY 463, 466, 1869, see also Cunningham v. Baker, 104 a la 160, 16 so. While the search and seizure provision of the Constitution regulates the manner in which warrants can be issued, it is the Due Process Clause which protects citizens from unlawful arrests without warrant. No person shall be deprived of life, liberty, or property without due process of law. And, under like restrictions in the Constitution, it has been held in some states that arrests shall not be made without warrant, except for felonies, and for breaches of the peace committed in the presence of the officer arresting. North v. People, 139 ill 81, 28 NE 966, 972, 1891. Page 2 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. 24. Thus, where an arrest is made without warrant, in a case not involving a felony or breach of peace, the arrest is unlawful. Arrest without warrant where a warrant is required, is not due process of law. An arbitrary or despotic power no man possesses under OUF system of government. Thus when a police officer exceeds his powers in making an arrest he becomes a trespasser and is liable for false imprisonment. Musco v. Commonwealth, 86 Virginia 443, 10 SC 534, 536. For other authorities on this matter see, 1 AM Law Republic, Anno, 585, et. Seq. Commander v. Carey, 12 Cusp. 246, Massachusetts, 1853, 6 ACJ.S, Arrest 10, p. 17, and Chrisson A. Treatise on the Law of Sheriffs, Vol. I, 166, 1941, Hill v. Day, 168 Kansas 604, 215 p.2d 219, Lee v. State, 45 Texas CRR 94,74 SW 28, 1903, 22 Midge. Law Review 673, 703-707, Ulvestad v. Dolphin, 278 p. 681, 684, Wash 1929, Enrique Kellum, 55 Kansas 700, 41 p. 960, 961, 1895, Pavish v. Myers, 225 Pacific 633, Washington, 1924, Delafoyle v. State, 54 NJL. 381, 24 all. 557, 558, 1892, Giroux v. The State, 40 Texas 99, 104, 1874. 1892, Staker v. U.S., 2F.2d 312, 314, 1925, Poner v. State, 52 SE 283, 285, GA. 1905, Cave. V. Cooley, 152 p.2d 886, NM. Conclusions. It is a maxim of law that liberty is more favored than all things, dig. Thus the law favors liberty above all things and applies the most liberal interpretation to it. The common law rule regarding the procedure and process for arrest was established in Ihie's country. In Aller v. Wainco, 43 Michigan 76, 97, 4 NW 492, 495-96. 1880, Mr. Justice Campbell says. The Constitution has also provided that no one shall be deprived of liberty without due process of law, and has provided that no warrant shall issue except upon oath or affirmation establishing probable cause. It has been settled for centuries, and the doctrine has been recognized here, that except in cases of reasonable belief of treason or felony, or breach of the peace committed in presence of an officer, there is no due process of law without a warrant issued by a court or magistrate upon a proper showing or finding. It is thus fundamental that the Due Process Clause of the Constitution protects the citizen from unlawful arrests. State v. Quinn, 97 SC 62, 64, SC 1918. By the common law, which is that law due process guarantees, a citizen cannot be summarily arrested when he is found violating a law that is only a misdemeanor. A warrant must first be acquired to arrest such a person pursuant to due process of law. If that which constitutes due process of law is made to depend upon the will of the legislature as expressed in a statute or charter, then no fundamental principles of law or rights are perpetuated or secured against abrogation. Page 12 of 13 Plaintiffs' Memorandum on Arrest Without Warrant. An arrest is a deprivation of one's liberty. The state constitution requires that no person shall be deprived of life, liberty, or property without due process of law. Minnesota Constant Art. I. Secretary. The procedure for arrest under TB common law is what constitutes due process today, as the Minnesota Supreme Court held. What is due process of law is usually a traditional or historical question. Was it due process of law under the common law, and did it remain such up to the time of adopting the Constitution? C.N. Nelson Lumber Co. v. M. Kinnan, 61 Minnesota 219. The law is very jealous of the liberty of the citizen. Where the offense is less serious, the grille or the formality prescribed for the exercise of the power which can deprive the citizen of his liberty. Poner v. State, 124 GA 297, 52 SE 283, 285, 1905. The citizen cannot be summarily deprived of his liberty because of his infraction of some ordinance or statute, unless at common law he was liable to arrest. The misdemeanor traffic statute involved in this case is such that it does not allow the defendant to arrest the plaintiff without TB formality of a warrant. Therefore, the defendant is guilty of false imprisonment for arresting the plaintiff without authority of law. The foregoing proves that the common law surrounding arrests was always recognized in this country and is thus a requirement for due process in depriving the plaintiff of his liberty. It is the law of the land. As such, these principles are constitutional mandates and cannot be abrogated by mere statutes. Respectfully submitted and stated, Juris et de jure, by Charles A. Weissman I 175 IW River Hills Dr. Burnsville, Minnesota. Page 13 of 13 Plaintiff's Memorandum on Arrest Without Warrant. 26. 4. Breach of the peace and felony arrests. What is a breach of the peace? A breach of the peace may be generally defined as a violation of the public order which amounts to a disturbance of the public tranquility, or by injuring others to do so. It is clear that not every misdemeanor is a breach of the peace. To constitute a breach of the peace there must be some violence or harm existing or threatened to occur to person, property, Health or morals. Affrays, assaults, riotous conduct, or destruction of property make up the largest part of what can be called a breach of the peace. Thus in the majority of cases of a breach of peace some actual violence is present. In some states there has been attempts to expand the meaning of breach of peace to include all indictable misdemeanors, but this it must be confessed is doing serious violence to a simple expression, easily and well understood. Some of the types of breaches of the peace are described as follows. Raj breach of peace includes acts of public turbulence, acts of violence or tending to produce violent eorte ending to incite violence, disturbance of the public tranquility by yelling ng, hollering, or uttering loud and vociferous language. Making disturbing noises on a public street by one in a state of intoxication, wanton discharge of firearms in a public place, engage in an affray or in an assault, uttering abusive, profane, indecent, or otherwise provocative language. In discussing what constitutes a breach of the peace, the Supreme Court of North Carolina held, a breach of the peace is a public offense done by violence or one causing or likely to cause an immediate disturbance of public order. Breaches of the peace are acts which are malum in se, being wrongful or evil by their nature. Thus acts which are malum prohibita, or those acts made wrong merely by a statute, cannot be classed as a breach of the peace. Those acts which constitute a breach of peace have been settled throughout the course of the common law. The legislature cannot declare any act they choose to be a breach of peace. The nature of the act determines if it fits the common law definition of a breach of the peace. The acts that are only malum prohibita include liquor prohibition laws, traffic laws, labor laws, health laws, food laws, building codes and zoning ordinances, safety acts, game laws, and very many other police regulations. Without a statute, most of the acts constituting these offenses would be innocent acts. A parade on the Slow-Read is not of itself a breach of the peace, though it could constitute. Walter Anderson, A Treatise 011 The Law of Sheriffs, Cor Allen, and Coi Lobiu. Vol. pp. 212 American Jurisprudence, 2d, Breach of Peace, 8. Pages 669-70. 3 Stott v. Mobvk, 240 NC 476, 83 S.E.2d 100, 104, 1954, authorities cited. 4 Allen Weisdale, 183 Wisconsin 323, 197 NW 808, 811, 1924. 1.S The carrying of arms in a quiet, peaceable, and orderly manner, concealed on or about the person, is not a breach of the peace. Nor does such an act, of itself, tend to a breach of the peace. 6 A mere trespass is not a breach of the peace and does not impose criminal liability upon the wrongdoer. 7. Driving an automobile while intoxicated constitutes a breach of peace. 8 Indecent exposure is where one is walking in public naked or nearly naked or in indecent dress is disruptive of the morals of society and constitutes a breach of the peace. Blasphemy of Christ or Christianity in public is a breach of the peace. A mere violation of public decorum or a penal law does not constitute a breach of peace. 9 Conduct merely amounting to a nuisance is not per se a breach of peace. 10 The sale of 15 dynamite caps to a 5-year-old boy did not constitute a breach of peace. 2 A theft is not in its nature a breach of the peace. 12 A charge of disorderly conduct is a broader term than a breach of the peace because a person who commits a breach of the peace is necessarily guilty of disorderly conduct. However, all acts of disorderly conduct are not necessarily a breach of the peace. Littering or yelling are such cases. 27 Breach of the peace is a common law offense, but it is not itself a specific offense. Thus in a charge or indictment the specific offense must be specified. Arrests for breach of the peace. In the struggle for government to claim and exercise greater powers of arrests, it has unlawfully attempted to apply the common law rule for a breach of peace arrest to all misdemeanors. The general rule of law under the common law for the arrest of misdemeanor offenses amounting to a breach of the peace is stated as follows. In cases of misdemeanor, a peace officer like a private person has at common law no power of arresting without a warrant except when a breach of the peace has been committed in his presence or there is reasonable ground for supposing that a breach of peace is about to be committed or renewed in his presence. An arrest can only be made to suppress and prevent the breach of peace, and if the act ceases, there is no longer justification for the arrest without warrant. A constable cannot arrest, but when he sees an actual breach of peace, and if the affray be over, he cannot arrest, and where a breach of the peace had been committed, and was over, the constable must proceed in. 5 in Shields y Stat. 181 Wisconsin 448 204 N. W 486, 40 ALR 945. 6 Wharton's Criminal Law and Proudhon, 12th ed., Vol. 2, Breach of the Peace, 803, p. 660, 1951, 12 American Jurisprudence, 2d, Breach of Peace, 8, pages 669-10, Judy v. Lashley, 50 West Virginia 628, 41 SE 191, 200, 1902, Robertson v. State, 43 FLA 156, 29 So. 7 Wharton, OPCIT, 804. 8 Stott Y. Rue, 72 NM 212, 382 p.2d 697, 700, 1963, State v. Jennings, 1120 HIO App 176 N.E.2d 304, 307. 9 Heron Y. Commonwealth, 294 Kentucky 31, 170 S.W.2d 861, 862, 1943. 10 Slate v. Moblook, 240 NC 416. 83 S.E.2d 100, 1954. 2 State v. Thompson. 117 VT 70, 84A.2d 594, 596, 1951. 12 Raidlov. National Food Slurs, 20 Wisconsin 2d 224. 123 N.W.2d 570, 1963. /3 Solyof Seattle. Franklin, 191 Washington 70 p.2d 1049, 1051. 14 Carolv. United States, 261 U.S. 132, 157, 1924, citing, Halsbury's Laws of England, Volume 9, Part 3, p. 612. 28. The same way as any other person, namely, b. Obtaining a warrant from a magistrate, s. The rule for arrest without warrant involving misdemeanors was stated in an article in the Michigan Law Review as follows: neither 0, a peace officer, nor c, a private citizen, may arrest d, a person, for m. a misdemeanor, which is not a BP, a breach of the peace. In regards to this rule it was stated, fn neither an officer nor a citizen may arrest for a misdemeanor which does not amount to a breach of the peace even though it occurs in his presence. As for example, talking loudly in the street in the presence of the officer, who ordered the parties to be quiet. An arrest without a warrant was not justified, nor where d in the presence of 0 was turning toward the wall for a particular purpose of relief, in the street, or where he was disturbing a public meeting, or obstructing the free passage across a bridge, or refusing to move on a sidewalk, at the request of an officer, or fraudulently substituting a smaller for a larger check, or fraudulently evading payment of a railroad fare, or maintaining a billboard on a sidewalk, or insulting the head of the house in the presence of his family, or assembling to witness a Sunday ball game, or a movie show. 6. It is a common rule that an officer cannot arrest for a breach of peace after it has ended. When a breach of the peace ceases, the reason for the arrest ceases, that being to stop or prevent the breach of public order. Mr. Bishop, in his treatise on criminal procedure, speaking on the subject of arrest for breaches of the peace says, after the tumult is over, with no prospect of its renewal, it is too late to interfere without judicial process. And other past misdemeanors are within the same rule, namely, that a private person, or even an officer, cannot without a warrant arrest one for a misdemeanor committed on an occasion already past. 1 Bish. Crim. Prust. The principle behind the common law rule of arrests was that in order to prevent harm, violence, or disturbance to the public peace, it is necessary that those perpetrating such acts be promptly stopped by arrest. Where, however, the offense is an accomplished fact, its prevention is no longer possible. Also, if public order has been fully restored before the officer appears. The power to arrest without warrant for a misdemeanor breach of the peace no longer exists, for the end by which such authority to arrest is allowed to maintain the public peace is no longer attainable. The occasions which would justify arrest without process for vagrancy would indeed be very rare, inasmuch it involves no immediate danger to public or private security. 19. Under American common law, no one can be required to give an account of themselves, or to show they have a visible means of support, or that they have employment. As part of the right to life, all have a right to choose how to live and how to. I.S. Still v. Lewis, 50 Ohio Republic 179, 185-33 NE 405,40607, 1893. Also, Pauth. Beck.NA, 3 IND.475,478, Commonwealth v. Gorman, 288 Massachusetts 294, 297, 192 NE 618, 620, 1934, 2 Hawkins PC, C13, 8 and an IHE English case of Regina v. Tooley, 2 Lord Ray. 1296, 1301, 11 Mod. 242, 250, by Lord Hall. 1622 Michigan Laurelio, 673, a wrestle without a warrant, pages citing cases including Fromelsbury's Laws of England. 17a. Quoted in, E.R. Payne Rhodes, 202 Ala 68, 79 So. 18 State 2. Lewis, 50 Ohio Republic 179, 187-33 NE 405, 1893. 19 Sarah Way's case, 41 Mitch. Support themselves, and no government act can interfere with this right. The majority of misdemeanor offenses would not fall into the class of a breach of the peace which allow the immediate intervention of authority by arrest, as they are not an offense of a grave nature, or because they do not actually disturb the public peace. An arrest for breach of the peace in the officer's presence must be made promptly, either at limo the offense or as soon as the circumstances permit. If the officer does not act immediately after the offense has been committed, he can thereafter make arrests only by procuring a warrant. When an officer, after having seen a breach of the peace committed, departs on other business or for other purposes, and afterwards returns, he cannot, without warrant, make an arrest for the offense. But where the officer finds it necessary to procure a stance, a reasonable time may be employed in the pursuit. In such a case the officer must at once set about the arrest and follow up the effort until the arrest is effected. An unreasonable delay will make the arrest invalid. In order to justify a delay, there should be a continued attempt on the part of the officer to make the arrest. It has been erroneously stated that officers are authorized to break in a house or building to prevent the commission of any crime without a warrant. This is an invalid. 29. Exaggeration of the true law on the matter, which is revealed as follows. The authority of a constable to break open doors in a RREST without a warrant is confined to cases where treason or felony has been committed, or if there is an affray or a breach of the peace in his presence. 2 HALEPE 88-96, 1 Hawkin S, C 63, 16, 1 Russell on Crime S, 629, Ichides Criminal Law, 14, 15, Bacon, Abridged Con Stab Le. C. 21. The cases in which a breach of the peace occurs in the presence of an officer when done in a building would be very rare. The cases of felony and treason in such a case would most often occur where the felon was pursued into a building by the officer. Public drunkenness unaccompanied by language or conduct which creates a breach of the peace, will not justify arrest without a warrant. 22 Impudent, abusive, or offensive language addressed to a peace officer does not tend to breach the peace, even though it may provoke the officer to anger. 23 And it has been held that the mere refusal to give one's name and address does not justify the incarceration of a citizen. 24. Threatened breach of the peace. An officer cannot arrest because he thinks or has suspicions that a breach of peace might be committed. The cause for arresting upon such cases must be when a breach of the peace is threatened or its occurrence is imminent. 25 In determining when officers 24 am juror arrest 67p46 Liaru Worley 152 Oklahoma 57,4p.2 D3 6 1931 Staln Lewis 50 Ohio ST 17933 NE 405,406 1893 21 Mickleton Richardson 15 Gray's Republic 74 77 Mass 22 Sile Mobley 240 NC 476 83 S.E.2 D 100 104 1954 Authorities cited 23 PA Ish v. Mayuse 129 Washington 605 225 Pacific 633,634 1924 Salem v. Coffey 113 MO App 675 88 SW 772 1905 People v. Lukowski 94 Miscellaneous 500 159 NYS 599 1916 Myers v. Callell / 1 Utah 2 D 406 268 P.2 D 432 434 1954 24 Skoye 2 Fielschmidt 191 Iowa 347 182 NW 382 384 Iowa 1921 30 may interfere by an arrest to prevent a threatened breach of the peace, the Supreme Court of Michigan stated. We are of opinion that a threat or other indication of a breach of the peace will not justify an officer in making an arrest, unless the facts are such as would warrant the officer in believing an arrest is necessary to prevent an immediate execution thereof, as where a threat is made coupled with some overt act in attempted execution thereof. The object of permitting an arrest under such circumstances is to prevent a breach of the peace, where the facts show danger of its being immediately committed. Point 26. Thus the interposition of the officer in a threatened breach of the peace is not for the purpose of an arrest but to prevent a disturbance or breach of the peace under a present menace of violence. The courts are almost unanimous in their holdings that a threatened breach of the peace will not justify an arrest without warrant, unless the facts are such as would warrant the officer in believing an arrest necessary to prevent an immediate execution thereof, as where the threat is made coupled with some overt act in attempted execution thereof. In such cases THC officer need not wait until the offense is actually committed. Point 27. The guideline then for making arrests on what is to be jailed a threatened breach of the peace, is when the conditions are such that the threatened breach of peace is imminent, or that it is obvious. 0. The average person that it is going to occur, as held by the Supreme Court of North Carolina. 25 PDA 2 Slot 227 MD 28 175 A.2 D 11 16 1961 26 Quinn v F1 DSD 40 Midge. Dole think a breach of the peace is threatened if the offending person's conduct under the surrounding facts and circumstances is such as reasonably justifies a belief that the perpetration of an offense amounting to a breach of the peace is imminent. Point 28. Since the nature of most breaches of the peace are such that cause violence to person or property, the acts which constitute them are apparent, so that one can readily see or hear them occurring. It is said a breach of peace is committed in one's presence when, by the use of his senses, he knows of its commission by the person about to be arrested. Thus an arrest for a breach of peace may be made when one's senses afford him knowledge that it is being committed, whether through sight, hearing, or other senses. 29 An arrest for a breach of the peace cannot be made on suspicion or mere belief. An arrest for a breach of the peace cannot be justified merely upon belief or suspicion existing in the mind of the officer, but where the actions of the person and the surrounding circumstances are such as to indicate a threatened breach of the peace, the arrest may be lawfully made. Point 30. It is thus said that an officer cannot arrest for a misdemeanor or a breach of the peace based solely upon information from another or suspicion without a warrant. In no case could advice or information given after the arrest was made justify the arrest. Likewise, an arrest cannot be made for one purpose and justified for another. 27 Hallerbeacon v. Hollingsworth, 250 SW 261, 265, Texas Civ App. 28 State v. Mobley, 240 NC 476, 83 S.E.2D 100, 104, 1954, authorities cited. 29 Restatement, Torts, Sector 119, Walker I. Unit Slates, 7 Federal 2D 309311, 9th Sir 1925, Warden S. Criminal Procedure, 101.1, Air C5T, 65, 12th ed., p. 173. 30 Hughes v. State, 145 Tennessee 544, 238 SW 588, 596, 1922. Conditions of felony arrests. It was regarded under the common law to be a right and a duty for a citizen to arrest one he sees committing a felony without a warrant. As stated by Justice Platt, all persons whatever, who are present when a felony is committed, or a dangerous wound is given, are bound to apprehend the offenders. 3 Hawkins, PC 157, MSL, S. 1. To arrest a person for a felony not witnessed by the officer, he must be able to conclude from the facts then existing that a certain person did commit the felony, so that any prudent person would be led to believe likewise. An arrest for felony based upon suspicion, belief, or rumor can never be justified for any cause whatsoever, not even by a warrant can such an arrest be lawful. Where there is a felony and it is past, the officer is justified in arresting though no offense has been committed, yet he must have had reasonable cause to suspect the one apprehended. 32. To allow arrests for suspicions, even in the case of felony, would make everyone susceptible to arrest who the officer might choose to believe is a likely or possible perpetrator of a crime. It would in effect amount to a general warrant in the hands of any officer, a concept which was found to be so abhorrent to the founding fathers of the American Revolution. All arrests for felonies not seen or witnessed by the officer or citizen making the 31. Arrest have the burden to justify the arrest. In a felony arrest by a private citizen, he must justify the arrest by showing that the felony had actually been committed, and that he had reasonable grounds for believing the person arrested to be guilty. 33. An officer is required only to show the probable cause existing for making the arrest, and need not show that a felony actually occurred, though such proof could serve as a justification. 34. In all other arrests, probable cause is not a factor in justifying an arrest without warrant. It is well settled at common law, that an officer or private person, without warrant, may lawfully seize and detain another in cases where a felony was about to occur. If 2 persons be fighting, and there be reason to fear that one of them will be killed by the other, it will be lawful to part and imprison them till their anger shall be cooled. Bacon, Abridged, Trespass, d. 2 Roll. Abridged and private persons may justify breaking and entering the plaintiff's house, and imprisoning his person, to prevent him from murdering his wife. 35. The law on felony arrest allowed all peaceable persons to travel freely anywhere without having to worry about an arrest or warrant for a felony. This is because all persons know what constitutes a felony, that being intrinsically evil acts such as murder, kidnapping, rape, arson, mayhem, armed robbery, and other such atrocious crimes. No one commits a felony accidentally or without foreknowledge of the act. Thus a felon's arrest comes as no surprise to him. 31 Phillips against Trull, 11 Johnson's Republic 486, 487, NY 1814. See also, 6A CJS Arrest, 13. 32 The State v. Underwood, 75 MO 230, 237, 1881, citing 1 Bishop's Criminal Procedure, 181, also see Commonwealth. 2. Carey, 12 Cush. 246, Massachusetts, Palmer v. Maine CENT Arco, 92 Me 399, 42 It. 800, 803, 1899, authorities cited. 33 Pomerve. Maine CENT Arco, 92 Me 399, 42 Atlantic 800, 803, 1899, authorities cited, Goley Bart v. Sullivan, 30 IND App. 428,66 N.E.188, 191, 1903. 34 Stale v. Noen, 354 MO 980, 192 SW.2 D 1016, 1020, 1946. 35 Colby. 2 Jackson, 12 NH 526, 530, 1842. 32. 5. Defenses to unlawful arrests. This section will be of benefit not only to those who may initiate a suit for false imprisonment, but also for peace officers as it further outlines what is the extent of their authority. Suits are usually brought about because there is not a meeting of the minds in regards to the facts or the law of a case. If both parties know the law of arrests and what can and cannot be used as a defense to acts of imprisonment, many lengthy and costly litigations can be avoided. Over the course of the history of arrests, there have been numerous defenses raised against claims of false imprisonment. Yet the basic defense for this charge is usually limited to showing that the arrest was pursuant to law, that the one arresting had lawful authority to so act. Thus a valid defense or proper justification for false imprisonment would normally be one asserting the legality of TB arrest. 1. As Justice Hand stated, the law watches personal liberty with vigilance and jealousy, and whoever imprisons another, in this country, must do it for lawful cause and in a legal manner. 2. Most of the erroneous defenses have been due to misconstruing the requirements of a suit for malicious prosecution with those required for false imprisonment. Burden of proof. In false imprisonment suits, or in allegations of false arrest, it can be no defense that the one who was arrested must prove that the arrest was unlawful in order to prevail in the suit. Due to the high regard placed on liberty, all imprisonments of a person are deemed unlawful until the contrary is shown. In Halsbury's Laws of England, in speaking on suits of false imprisonment, it says, the plaintiff need not prove that the imprisonment was unlawful or malicious, but establishes a prima facie case if he proves that B was imprisoned by the defendant. The onus then lies on the defendant of proving a justification. The only thing the plaintiff needs to plead and to prove is one of two things, either, 1. that the defendant made an arrest or imprisonment, or, 2. that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. 4. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. Thus it has been held that in false imprisonment suits the defendant, in order to escape liability, must either prove that he Marks v. Ballymore and 0. Arco, 131 N.Y.S.2 D 325, 327, 284 App.div. 2 Pratt v. Hill 16 Barb. Republic 303,308, N.Y.1853. 3 Earl of Halsbury, That Laws of England, Vol. 38, 3rd ed., pt 4, 1266, p 765, London, 1962. 4 Burlington Transp. v. Joseph Son, 153 Federal 2d 372, 276, 1946. 5 People v. McGrew, 77 Calories 570, 20 Pacific 92, 1888, Knight v. Baker, 117 Oregon 492, 244 p. 543. Did not imprison the plaintiff or he must justify the imprisonment. 6. Stated another way, the burden is upon the defendant to show that the arrest was by authority of law. In a case where 2 police officers arrested a man whom they believed commit into felony, the jury was instructed that the burden of proof, by a fair preponderance of the evidence, was upon the plaintiff to show that the arrest and imprisonment were not justified. This instruction was held to be wrong on appeal, where the court stated, it was long ago said by Lord Mansfield, a jailer, if he has a prisoner in custody, is prima facie guilty of an imprisonment, and therefore must justify. Badkin v. Powell, Caup. So, in Holroyd v. Doncaster, 11 More 440, it was said by Chief Justice Best, where a man deprives another of his liberty, the injured party is entitled to maintain an action for false imprisonment. and it is for the defendant to justify his proceeding by showing that he had legal authority for doing that which he had done. Where the arrest was done without a warrant, the person arresting would have to justify by showing he acted pursuant to due process of law, by showing that there was a felony or breach of peace committed. Where an officer arrests a person without a warrant, the burden rests upon the officer to plead and prove justification. Otherwise the arrest is prima facie unlawful. 9. In a case in Iowa, TB Mayor of Aon had instructed the town marshal to arrest a man because it had been reported that he was drunk. 33. And had been disturbing the peace. The marshal arrested the man in his home without a warrant. When the man sued the mayor and marshal for false imprisonment, the court instructed the jury that the burden of proof was upon the plaintiff, the man arrested, to prove that he was not found intoxicated when arrested. On appeal, the Supreme Court of Iowa held that the court announced an incorrect rule of evidence on the matter. The Supreme Court, in defining the correct rule, stated: in 2 Bishop on Criminal Procedure, 368, it is said, in matters of evidence, if the imprisonment is proved, its unlawfulness will be prima facie presumed, but authority may be shown by the defendant in justification. 10. If the marshal bad a valid warrant, this would serve as justification for the arrest, and as a defense to the charge of false imprisonment. Being B had none, and he witnessed no breach of the peace, he had no defense against TB charge. The rule of burden of proof is the same in a criminal proceeding, where any arrest made without a warrant, if challenged by the defendant, is presumptively invalid, and the burden is upon the state to justify it as one not only authorized by statute, but also as one not violative of constitutional provisions. The invalidity of the arrest will render the search invalid and the evidence obtained inadmissible. This was so held in Testelin v. State. 205 NW 825, Wisconsin 1925. 6 Southern Rico v. Sheralty, 121 Kentucky 863, 90 SW 597599, 1906, citing, 12 AM. D. Pound N8. Pound NCY. Ola, 2D ed. P 733. 7 Galeri. Good, 216 PA 473, 6581. 934, 935, 1907, Mackey v. Ambassador Hotel and Inni. Co. 123 Calories App 215, 11p.2d 3.6, 1932. 8 Jackson Y. Knowlton, 173 Massachusetts 94, 53 NE 134, 1899. 9 Pound Jens Y. Jorgensen, 182 Minnesota 282, 234 NW 292, 293, 1931. Cases cited. 10 Snyder Y. Thompson, 134 Iowa 725, 112 NW 239, 241, 1907. 2 Slow Y. Moss Ryan, 285 Minnesota 51, 56 57, 171 N.W.2D 695, 1969, Beleri. Stale, 212 So.2D 573, 577, Miss, 1968. 34. Good faith and probable cause. The most common defense raised in false imprisonment suits is that the arresting officer acted in good faith or with good intent. This argument of defense is often raised along with the defense that the officer had probable cause. Both of these defenses are often misapplied to the action of false arrest. Such defenses are more applicable to suits involving malicious prosecution or abuse of process, rather than to false imprisonment. As stated by the Supreme Court of Iowa, false imprisonment is the unlawful restraint of an individual's personal liberty or freedom of locomotion. The good faith of the actor is no justification, nor is the 1L of probable cause an essential element, as in the case of malicious prosecution. In cases of false imprisonment, the only essential elements of the action are detention and its unlawfulness. Thus malice and the want of probable cause need not be shown. 13. or are not necessary to a proper cause of action for false arrest, /4 even where the unlawful arrest is claimed to have been for the public good, such a defense will not stop damages. It is well settled law that the want of reasonable or probable cause and the want of malice are elements not entering into the action of false imprisonment in so far as actual damages are concerned. Point 1s. The question of probable cause, in its usual sense, is not involved in the action for false imprisonment. Thus, according to the great weight of authority, the existence of probable cause is not an element of nor a defense to an action for false imprisonment. A case in South Dakota developed where a sheriff bad, due to mistaken identity, arrested the wrong person as an embezzler upon a warrant which did not name or describe the person to be arrested. The sheriff alleged good faith and probable cause for arresting the man. The state Supreme Court held that the fact that the sheriff acted in good faith and with probable cause was no defense, and may not be taken into account in denying the damages which will compensate the plaintiff. In many cases, officers will try to justify an arrest for a misdemeanor based upon a strong belief that the person arrested is guilty. In such a case, the Appellate Court of Illinois held, in an action for trespass and false imprisonment, probable cause and the absence of malice constitute no defense. And this form of action, belief in the guilt of the party arrested, no matter how strong or well-founded in the mind of the officer or person making the arrest, will not justify the deprivation of another of his liberty. And it is unimportant whether the circumstances would lead a reasonable or prudent person. 12 Sergeant. If Watson Brothers Transpo, 244 Iowa 185, 52 N.W.2 D86, 92. Citing, Maxwell. If Maxwell, 189 Iowa 7, 177 NW 541, 1920. 13 Sinclair Refining County. If Meek, 62 GA App. 850, 10s.e.2 D76, 79, 1940. Authorities cited. 14 Stallings. If FOSLTR, 119 Cal.app.2 D614, 259 P.2 D 1006, 1009, 1953. 15 Carter. If Cast, 153 S.W2 D 744, 746, MO numerous CASES cited therein. 16 Erardle. If Wells Fargo Day, Co., 134 Minnesota 58, 158 NW 721, 722, 1916. 17 S. Afford. If Vermilion, 261 P.2 D 187, Oklahoma 1953. Seconds also, 35 Corpus Juris Secundum, false imprisonment, 7, p. 631, 32 American Jurisprudence, false imprisonment, 6, 7, p. 64, 114, p. 178, Hosletler L.F. Carter, 175 PAC. Oklahoma, 1918. 18 Benai. Bissell, 77 SD 433, 93 N.W2D 403, 1958. To believe that the accused was actually guilty. 19. In some cases, instead of asserting that the officer acted in good faith, the defense is raised that malice must be proven on the part of the arresting officer. This defense is, however, groundless in matters of false imprisonment. In an action for false imprisonment, neither actual malice nor want of probable cause is an essential element necessary to a recovery of general damage s.io. Whatever the motives of the arresting officer, they do not cause or bring about a change in the legality of an arrest, as was asserted by the Supreme Court of Missouri. A lawful imprisonment does not become unlawful because of malicious motives, nor does an unlawful detention become lawful because actuated by a laudable purpose or founded in good faith. 11. Closely related to the defense of good faith or lack of malice is that an arrest is justified where there is no force or injury done to the person arrested. But as the United States Court of Appeals stated, this does NQ justify an arrest All that is necessary to establish false imprisonment is that an individual be restrained of his liberty under the probable imminence of force without any legal cause or justification. 3-4. It is not necessary to show actual force, threats, or injury done to the individual's person, character, or reputation. The lack of malice, the presence of good faith, or the presence of probable cause do not affect the existence of the wrong when the detention is unlawful. 22. 19 Morkey v. Griffin, 109 Ill App. 35. Where a deputy game warden had arrested a man without warrant and incarcerated him in the county jail, the deputy claimed that at the time of the arrest he had probable cause for believing that plaintiff was then violating the law by hunting without a license. It was held that there was a false imprisonment involved, as the Supreme Court of Alabama said. In false imprisonment, the essence of the tort is that the plaintiff is forcibly deprived of his liberty, and the good intent of the defendant, or the fact that he had probable cause for believing that an offense was committed and acted in good faith, will not justify excuse the trespass. 23. In an action against a mayor and a police court judge for alleged false arrest and imprisonment, it was claimed that the defendants acted maliciously with a design to injure the plaintiff. It was held by the Supreme Court of Kansas that based upon the claim of malice, the defendants were not liable for false arrest. The proper remedy would be an action for malicious prosecution. The court also stated, the motive with which a restraint of liberty is accomplished, be it evil or good, is irrelevant to the question of whether or not an unlawful arrest has been established. The existence of actual malice is of consequence only as it may afford the basis for punitive damages. In Garney v. Squires, 62 Kansas 321, 62 p. 1005, the court said, as will be seen, malice and willfulness are not essential elements of false imprisonment, and motives of the defendant, whatever they may have been, are not material to the case. H. 20 MCNFV. H. Ider, 337 p.2 d 819, 821, or, 1958, 35 CJ.S. False Imprisonment, 7, pp. 21 Thompson I. Farmers Exchange Bank, 333 MO 437, 62 SW, 2D, 803. 811, MO. 22 Nesmith v. Aylford, 318 F.2 D 110, 11819, 1963. Authorities cited the reign. 23 Daniel S.L. Milstad, 221 Ala 353, 128 So. 447, 448, 1930, de Armand I. Sondm, 243 Ala.263, 9 So.2 D 747, 751, 1942. 24 Holland v. Lutz. 194 Kansas 712, 401 p.2 D LOIS, 1019, 1965. 36. And the Court of Appeals of Maryland had stated, in false imprisonment suits the essence of the law consists in depriving the plaintiff of his liberty without lawful justification, and the good or evil intention of the defendant does not excuse or create the tort. 11 RCL. Any deprivation by one person of IHE liberty of another without his consent, constitutes an imprisonment, and if this is done unlawfully, it is false imprisonment, without regard to whether it is done with or without probable cause. 2s. In a case of false imprisonment, the defendant claimed that the petition did not state a cause of action, for the reason that it was not alleged that the imprisonment was malicious and without probable cause. The trial court held that these claims were only valid in suits for malicious prosecution, and that there was a marked distinction between malicious prosecution and false imprisonment. The Kentucky Court of Appeals affirmed this position with various cites. In Starkey's Evid. 1112, it is said, no proof of malice or want of probable cause is necessary to make a case for false imprisonment. 26. Where the life, liberty, or property of the citizen are at stake, good intentions are never good enough. It has been stated that the citizen's liberty must not depend upon good faith merely, but upon legal rules governing official action. It has been held many times that in cases of false imprisonment, the defendant can only avoid liability for false arrest by pleading justification for the arrest. 28. All other arguments must necessarily fail. Ignorance of law. It is a fundamental maxim of law that ignorance of the law is no excuse to violating it. One such maxim is as follows. Ignorance of the fact excuses, ignorance of the law excuses not. Every man must be taken to be cognizant of the law, otherwise there is no saying to what extent the excuse of ignorance may not be carried. 29. It has been said that an unlawful detention or imprisonment does not become lawful because done out of ignorance of the law. The Georgia Court of Appeals Basbeld Tbat. It is no defense that a person perpetrating an illegal arrest or imprisonment is ignorant of the illegality of his acts. 31. Knowingly committing an arrest which is illegal is sufficient to fix liability. False imprisonment is treated as a ton, and also as a crime if the conduct is unlawful. Neither good faith, nor provocation, nor ignorance of the law is a defense to the person committing the wrong. 32. After speaking on the constitutional rights of citizens, the Supreme Court of Minnesota further adds. 25. Mahan v. Adam, 144 MD 355, 124 all. 901, 905, 1924, cases filed. 26. Solheim Rico and K. N. Lucky v. SHJRF, 121 Kentucky 863, 90 SW 597, 599, 1906, authorities filed. 27. Hill v. Wirozdik, 216 Ala 235, 113 So. 28. Kraft v. Montgomery Ward & Co., 348 p.2 d 239, 243, or 29. Maxims of Law, C.D. C. A. Weissmann. 57 f. 1 Koch, 177, 4 BVIRS in JLIUES, and 3828. 3035 Corpus Juris Secundum, False Imprisonment, 7, p. 630. 31 Sumbridge v. Ryle, 32 GA App. 587, 124 SE 115, 1924. 32 Krogerv. Patchmore. 36 Monell. 504, 93 Pack. Ali is the case of illegal arrests. The officer is bound to know these fundamental rights and privileges, and must keep within the law at his peril. 3J. Ignorance cannot be an excuse for violating the rights of citizens or any constitutional mandates such as due process, especially by those who have taken an oath to uphold that law. They become a hypocrite upon the assertion of such an excuse. Guilt of party arrested. An unlawful arrest cannot be justified because the arrested party was actually guilty of the charge for which he was arrested. The person charged with an offense can only be deprived of his liberty by due process of law. And this constitutional safeguard applies to the guilty as well as the innocent. Thus TB guilt of the one arrested has no bearing on the legality of an arrest. As stated in annotation 25A.Lr. No one can recover damages for a legal arrest and conviction, therefore, in cases of malicious prosecution, it becomes necessary to await the final determination of the action. But TB same principle does not apply to an action for false imprisonment, as the form of action is based upon an illegal arrest, and no matter ex post facto can legalize an act which was illegal at TB time it was done. 4. Thus nothing that happens ex post facto after the fact of the arrest, can change the legal nature of the original arrest. A prosecution and verdict of guilty does not make an unlawful. 37. Arrest lawful. In a case of false imprisonment where it was being asserted that the plaintiff was guilty, the Supreme Court of Oklahoma said, the guilt of the plaintiff is not material. JS in the Michigan Law Review it was stated that an arrest is unlawful, even if the arrestee be guilty of a felony, if the officer had not reasonable ground to believe him guilty. Thus neither the guilt nor innocence of the person arrested has anything to do with the legality of the arrest. 36. It thus has been declared that in an action for false imprisonment, the termination of a prior proceeding in favor of the one deprived of his liberty is not material to his suit. 37. Since termination of the proceedings is not material, the fact that the one deprived of his liberty was actually found guilty is immaterial to the false imprisonment suit. But in a suit for malicious prosecution, there must be a termination in the proceedings in favor of the party deprived of his liberty to prevail. If he is found guilty, he cannot sue for malicious prosecution. A false imprisonment case in New Jersey occurred where a woman was committed to an insane asylum by a business partner, and was released a few days later by her husband. The woman sued the partner for false imprisonment, but it was argued that the woman failed to plead or prove that the proceedings leading to her arrest and imprisonment in the asylum had terminated. The appeals court said that the argument raised did not apply to this case as it was in J. Theed H. Town 0/Scandia Valley, 217 Minnesota 218. 231, 14 N.W, 2D, 400, 1944. 34 Sergeant V. Watson Baru. Transpco, 244 Iowa 185. 52 N.W.2D 86, 9293, 1952, citing Navov. Costa, 5 calories app.L11. 89 Pack. J.S. Halliburton Abbott Co. 2 Hodge, 44P.2D 122, 125, Oklahoma, 1935. 36 Michigan Laurelio. Vol. 31, April, 1933, p. 750, citing numerous cases. 37 Reg/2. Hygrid Sud CQ, 47F.Sup. 293, 1942, Thompson v. Farmers Exchange Bank, 62S.W, 2D, 803810, MO. 1933, 25 American Law Reports, Annotation, p. 1518. 38. Action for false imprisonment, and not malicious prosecution. The court held. The weight of authority is against the proposition that in a suit for false imprisonment the prosecution should terminate before a suit for damages can be instituted. In a suit for false imprisonment, a record of conviction for the same offense for which the arrest was made is inadmissible. 39 An action for false imprisonment is to be based upon the legality of the arrest, not upon the filing of a complaint, or the proof of an alleged crime, or the results of a trial, as the California Supreme Court said. The finding of guilt in the subsequent criminal proceeding cannot legalize an arrest unlawful when made. Even where a party has pleaded guilty, the one making the arrest can still be liable for an illegal arrest. 41 Thus it has been held that consent to an unlawful arrest will not excuse an officer or person from their acts, as held by a Federal Circuit Court of Appeals. We are of opinion that the law does not permit the citizen to consent to unlawful restraint, nor permit such a claim to be made upon the part of the defendants. In Warden on Criminal Law, Vol. I. 751e, it is said, no man has a right to take away another's liberty, even though with consent, except by process of law. And the reason is, that liberty is an unalienable prerogative of which no man can divest himself, and of which any divestiture is null. 1.42. Immunity. The argument of official immunity would seem to be an obvious and logical argument for an officer in defense of a charge of false imprisonment. Government is generally immune from being sued, and peace officers are regarded as members of government, thus it is often claimed they are immune from suit. But the immunity doctrine does not extend to anyone in government who causes a wrong. But immunity from suit is a high attribute of sovereignty, a prerogative of the state itself which cannot be availed of by public agents when sued for their own torts. Under the doctrine of official immunity there have been distinctions made between acts that are discretionary duties, which an officer in performance of is immune, and acts which are ministerial duties, for which officers remain liable. An officer's official duty is described as ministerial, when it is absolute, sine, and imperative, involving merely execution of a specific duty arising from fixed and designated facts. 44 An arrest by an officer is a ministerial, not a discretionary act. 38 Bosch v. Kick, 98 NJ Law 183, 119 ATL. I. 2, 1922, 25 ALR 1516, 5 AM Jut. 2D, Arrest, 22, p. 712. 39 Dunnell Minnesota Digest, 3 TD ed., Volume 8A, false imprisonment, 1.06, c, citing Wall v. Walton, 30 Minnesota 506, 16 N.W.397, 1883. 40 Coverstone v. Davis, 38 Cal.2D 315, 239 P.2D 876, 878, 1952, Wilson v. Lustelot, 85 Cal.App.2D 316, 193 P.2D 127, 132. 1948, Stewart v. State, 244 S.W.2D 688, 690, Texas Civ App, 1951. 41 Holzolve. Simmons, 258 Wisconsin 234,45 N.W.2D 683, 687, 1951, Anderson v. Foster, 73 Idaho 340, 252 P.2D 199, 202, 1953. 42 MDNTS v. Huntington, 276 Federal 245, 250, 1921, other authorities cited. 43 Hopkins v. Clemson Col Edge, 221 U.S. 636, 642-43, 1910, Johnson v. Langford, 245 U.S. 541, 546, 1917. 44 Rico v. Stale, 472 N.W.2D 100, 107, Minnesota, 1991. 39. 6. The use of a warrant in arrests. The requirement for warrants in the seizure. 0. Persons and property is an affirmation of common law principles. The declaration in our constitutions prescribing the mode in which may are to issue, reflects the abhorrence of the SE of the so-called general warrants. Will bear be easy and arbitrary arrests and seizures are made. Despite such declarations for the security of liberty, privacy, and property, history shows. The executive department has strong tendencies to disregard and violate them, as revealed by the U.S. Supreme Court. Though the police are honest and their aims worthy, history shows they are not appropriate guardians of the privacy which the Fourth Amendment protects. While the Fourth Amendment has been badly violated, we find that the due process of law provision is virtually ignored when it comes to warrants. For the most part it is the due process provision which prescribes the AQL requirement of a warrant for all arrests except where public security allows a warrantless arrest. Warrant to be in the possession of the arresting officer. A warrant of arrest is a written order issued by a court or magistrate, directed to a peace officer or to a specified private person, ending him to arrest a named person. 2. It is regarded as fundamental law that where one cannot arrest without a warrant must. Jones v. United States, 362 U.S. 257, 273, 1959. Be acquired and be in the actual possession of the one making the arrest, otherwise he is not protected by it. The requirement of having the warrant for arrest in actual possession is the common law rule and thus is part of due process of law, as it is a procedure which deprives a citizen of his liberty. In a case where a policeman, by direction of a sheriff, arrested an individual pursuant to a warrant, it was claimed the arrest was unlawful since the sheriff retained the possession of the warrant in his office. The Supreme Court of North Carolina held that the overwhelming weight of authority for misdemeanor charges is that the officer must have the warrant in his possession. The court stated the following. In 6 CLS, Arrest, 4, p. 576 ETSEQ, we find the general rule stated as follows: the warrant must at the time of arrest be in the possession of and with the person purporting to act thereunder or of one with whom he is acting in conjunction. Accordingly, where the warrant is at the officer's house some distance from the scene of the arrest, or in the hands of another who is not at the scene of arrest, or in the central office of a city detective bureau, the arrest is unlawful. 3. Since there was no felony or breach of peace committed in the presence of the policeman, his arrest was deemed illegal despite the fact there was a valid warrant for the individual arrested, since it was with the 2 Wharton's Crimina. Procedure, Vol. 1, 121 H. ed., 54, p. 151. 3 Alexan.derv. Linear CE, 230 NC 663, 55s.e.2d 470, 474, 1949. 40. Sheriff who was in another town. The court also said that the good faith of he policeman did not affect the unlawfulness of the arrest. A Mississippi case involved a warrant that was issued for the arrest of a Bill Smith on a reckless driving charge. Under the sheriff's instructions, a deputy went to Smith's home to arrest him while the warrant remained in the sheriff's office. Smith asked to see the warrant for his arrest. The deputy replied that he did not have it with him, but that it was at the sheriff's office and Smith could see it when they arrived there. However, Smith said he would have to see the warrant before he would submit to the arrest. Smith resisted the arrest. The sheriff was called out but came without the warrant. Smith again resisted but was forcibly taken to jail. The state Supreme Court held the arrest unlawful. Under the great weight of authority, an officer making an arrest for a misdemeanor not committed in his presence must have the warrant for such arrest in his actual possession if the arrest is to be lawful. In a criminal case involving a violation of a lien, a policeman was given a warrant for the arrest of a man named Shaw. He drove to Shaw's house in a buggy. He left the warrant in the buggy being some 150 yards from the house. The officer went into the house and put his hand on Shaw's shoulder and told him that he had a warrant for him and to consider himself under arrest. Shaw asked, "What for?" The officer replied, "For disposing of property under lien, and that a Mr. Bradham had sworn out the warrant." Shaw said, "I am not going." He resisted the arrest and claimed at trial that the arrest was not valid as at the time of arrest the officer had not actual possession of the warrant. The state Supreme Court held that the warrant was in fact in the officer's possession. The authorities agree that in cases of misdemeanor not committed in his presence, and for which he cannot lawfully arrest without a warrant, the officer should have the warrant in his actual possession at the time of making the arrest. It was not necessary that he should have the warrant in his hand or in his pocket at the time of making the arrest. Actual possession of it does not mean that the rule is satisfied if the officer has such possession of the warrant that he can produce it with reasonable promptness on demand. 1. The question of what constitutes possession of the warrant has often been debated, but it is obvious that it must be so close at hand as to show it upon request. Thus it need not be said that the warrant must in all cases be directly in the hand of the arresting officer. This would be too narrow and technical view of the law and one not based on substantial grounds. One reason for actual possession is to show the authority for the arrest, another is to display or read the warrant, and since this is to be done promptly the possession must exist. Thus the warrant must be in possession but not necessarily in hand, as the Federal Circuit Court of Appeals stated. The officer who seeks to arrest by virtue of a warrant must have the warrant in his possession at the time of the arrest. We need not undertake to define exactly what is meant by in his possession. Of course, it does not necessarily mean that the warrant shall be actually in his hand. Where a warrant was directed to all police officers, and exhibited to 2 officers but was kept in the police station, the warrant. For Small v. Sile. 208 So.2d 746, 747, Miss. 1968. Although an officer upon seeing a misdemeanor being committed cannot arrest the person committing it, he can in most cases stop him from committing it or prevent its continuance. Thus in observing a petty theft, an officer can stop the suspect, which would be an arrest, to recover the items taken. 5 Stain. Shaw, 104 SC 359, 89 SC 322, 323, 1916. Is not sufficiently in the possession of the officers to sustain an arrest by them. In the rather famous and landmark case of Crosswhite v. Barnes, a warrant for the arrest via FRS Barnes was issued by a justice for a NS. Demeanor, and placed in the hands of T. Crosswhite, Chief of Police. Crosswhite, along with a police sergeant, set OJ1Q execute the warrant, but left the V.RNT of arrest in his desk at the County Use. When the officers first saw Mrs. Barnes, she was driving down State Street in her automobile. The police turned their car in front of Mrs. Sarn's car to stop her. One officer opened her car door, took hold of her by the arm, and said, "Get in my car." She refused and told the police she would not go any here without her husband. The policeman said, "We want you, not your husband." She asked the officers to show her the warrant. Mr. Crosswhite said he did not have to do so, and said that you are going. Lo, the courthouse. The argument continued, ending in Mrs. Barnes being forcibly taken to the courthouse. Mrs. Barnes brought an action against Crosswhite and the other policemen for illegal arrest and assault and battery. The police were found guilty, and on appeal the Supreme Court of Appeals of Virginia affirmed the conviction, and in a very authoritative decision stated, "The textbooks generally state, and many cases hold, that it is necessary not only that a warrant of arrest should have been issued, but that the officer making the arrest shall have it with him and show it on request." In Beal Crim Pi. End Pro 18, it is said, an officer arresting on a warrant must have the warrant with him, and must show it on request. 41. In 1 Bish. New CRIMPROC 190, it is said, to justify an arrest under a warrant, the officer must have it in possession, and, if though delivered to him, he leaves it at his office or station house, it will not protect H. 1M. In 2 RCL, Ruling Case Law, 465, 23, speaking of misdemeanors not committed in the presence of the officer, it is said, the officer should bathe the warrant in his actual possession in order to justify the arrest, and if he does not have it, although it has been duly issued, an officer making an arrest may not be protected by it. 8. The court also referred to and relied upon a previous case in Virginia, the case of Musco v. Commonwealth, in which a policeman undertook to arrest Musco for a past misdemeanor, without a warrant, and Musco shot and killed him. He was convicted of murder, and in the appeal the court reversed the conviction, stating, "Indeed, not only must there be a warrant in the class of cases last mentioned, misdemeanors but, to justify the arrest, the officer must have the warrant with him at the time. 9. Since a warrant must be in one's possession to arrest, a sheriff has no authority to send a deputy to one place to make an arrest without a warrant, while he goes to another for the same purpose with the warrant. Nor can he send his deputy into one town while he gives pursuit in another. 10. Under the ancient practice of hue and cry, before warrants were issued, this might be done in the pursuit of felons, but no hue and cry could be raised for a misdemeanor. 6 Q. Halloran v. M. Gierk, 167 Federal 493, 495, 93 CCA 129, 1909. 7 P. Oppelt v. Fish F.J., 273,111. App. 8 Crossview. I. Barnes, 139 Virginia 471, 124 SE 242, 245, 1924. 9 Musco v. Commonwealth, 86 Virginia 443, 10 SE 534, 1890. 10 McCullough v. Greenfield, 133 Michigan 463, 95 NW 532, 533, 1903. 42. We think it clear that in cases of misdemeanors the sheriff must be present either in sight or hearing, directing the arrest, to justify a person not armed with the warrant to make the arrest. In a Georgia case, a warrant was issued for the arrest of Shaw, charging him with a misdemeanor. The warrant was directed to any sheriff, deputy, coroner, or constable of the state. When a constable tried to arrest Shaw at his home, a friend named Adams interposed and asked the constable if he had a warrant for Shaw. The officer replied that he had it at his home, but not with him. Adams thus prevented the arrest of Shaw and liberated him from the custody of the constable. Adams was charged with interfering with the arrest. The Supreme Court of Georgia held that Adams was not guilty of any offense since Shaw was not legally in the custody of the officer by virtue of a lawful arrest. The constable had no authority to arrest except under the warrant which he did not have in his possession. The court held, whenever a warrant has been issued to arrest a person charged with an offence in respect of which he cannot be apprehended without a warrant, the police officer must have the warrant in his possession at the time when he executes it. If he has not, the arrest will be illegal. Later the court upheld this case under a similar situation, where a warrant had actually been issued for an arrest, but the warrant was in the hands of the sheriff a number of miles away from where the arrest took place. The arrest was not lawful as the officer making the arrest had not been in possession of the warrant. 13. In many cases unlawful arrests have occurred where an officer receives some sort of communication from another jurisdiction or a central office that a warrant exists for the arrest of a particular individual. The officer relying on such information and making an arrest upon it is liable for false imprisonment, as be arrested without a warrant in his possession. 1 TREATISE says. In a case Holcray the officer of an city, county, or district, telephones to officers of another city, county, or district to make an arrest of a party with the last mentioned city, county or district. It affords the officer attempting to carry out the instruction no protection and the arrest is illegal, unless such officer would have a right to arrest without a warrant. 14. Thus where an officer was informed by a letter, written by the chief of police of a city in another state, that a certain person Bass absconded with funds belonging to a benevolent association. The officer was liable in damages for the arrest of this person without a warrant. The fact that a person knows that a warrant for his arrest is outstanding does not eliminate the need for possession of the warrant in making the arrest. In Anderson's Treatise on Sheriffs, it states, where arrest is being made under the authority of a warrant, the officer attempting to execute same, and arrest the party named therein, must be in possession of SAID warrant or it affords him no protection. The necessity for the possession of the warrant is not relaxed by reason of the fact that the AR to be arrested knows of 2 Kralt Serv. Malhite WS, 233 Michigan 452, 206 NW 982984, 1926, citing, P. Toppelt. 2 Mealtall, 68 Michigan 480, 36 NW 231. 12 Adam L. V. Seil, 121 GA 16-3, 48 SE 910, 911, 1904. 13 Jidls. Lot Slat, 154 GA 54, 113 SE 386, 389, 1922. 14 WA Iter H. Anderson A. Tritalist 011 That Loafstrifts. Yul. 1, 133, pp. A sheriff is liable ir he arrests less for a misdemeanor when acting upon a telegram stating a warrant exists. Robters Veed Tall, 187 So. 571, FLA 1939. 15 Maycom Soil v. Scott, 56 Michigan 459, 23 NW 166, 1885. The issuance and existence of such warrant for his arrest. Thus where an arrest is made without 2 Vinghi warrant in the possession of the arresting officer, such an arrest is treated as lugbit were made without a warrant. Warrant to be shown upon arrest. Coupled with the requirement to have the errant in possession when making an arrest, is the requirement to show or display the // nt to the arrested person. Where an arrest is claimed to be made under the authority of a warrant, it is the duty of the one making the arrest to show the warrant and read it to the one being arrested. Especially when he requires to see it or demands to know the nature and cause of the arrest. He need not submit if this is not done. In the case of Smith v. Stare, Supra, the Supreme Court of Mississippi not only said that the warrant must be in the actual possession of the officer, but he must show it to the accused, if requested to do so. 7 In Stale v. Shaw, Supra, the court said that the reason that a warrant is to be in the actual possession of the arresting officer is that, if demanded, he must produce the warrant and read it to the accused, that he may know by what authority and for what cause he is deprived of his liberty, /8. In Crosswhite v. Barnes, Supra, it was slated that the arresting officer must have the warrant with him, and must show it on 43. Request. It cited a number of authorities in support of this, such as the following. In the annotator's summary of a note in 42 LRA at page 682, it is said, an accused person, if he demands it, is entitled to BAV TB warrant for his arrest shown to him at the time of arrest. See also 51 LRA 211.19. In an early case in New York, a special deputy was charged with the duty to serve a warrant for larceny, issued by a justice of the peace. The person arrested required the deputy to show him the warrant, before he would submit to the arrest. The deputy did not do so and the man resisted and the deputy beat him. At trial the judge charged the jury that if the defendant did not show the warrant to the man, he was a trespasser. The jury found a verdict in favor of the man arrested. The Supreme Court of New York upheld the verdict stating, "A special deputy is bound to show his warrant if requested to do so, and if he omit, the party against who the warrant is may resist an arrest. And the warrant under are such circumstances is no protection against an action for an assault, battery and false imprisonment. Failure to show or display a warrant when a warrant for an arrest allegedly exists, the arrest becomes illegal." On this matter the Supreme Court of Georgia stated, in Galfiard v. Lax Elon, 2 Best and S. 363, 9 Cox. CC 127, it was held that in a case in which a lawful arrest could not be made except under a warrant, the arresting officers were bound to have the warrant ready to be produced if required. That an arrest in such a case by police officers who did not have the warrant in their possession at the time was illegal. 16 Walter H. and Carson A. TREATISE all Hilawy Sheriffs, Coroners and Collilables, Vol. I, 133, p. 128, 1941. 17 Smith I. State, 208 So.2d 746, 747, Miss, 1968. 18 State I. Shaw, 104 SC 359, 89 SC 322, 1916. 19 Crosswhite v. Barnes, 139 Virginia 471. 124 SC 242. 20 Froslow v. S. Thomas, 24 Wendell's Republic, NY, 418, 419, 1840. 21 Adams v. State, 121 GA 163. 48 SC 910. 44. Thus the primary reason for the officer to have the warrant in his possession when making an arrest under the warrant, is so that it can be shown to the one arrested, so that he knows the authority by which he is being deprived of his liberty. This was so held by the Supreme Court of Texas. It ought not to be denied that the law contemplates that the warrant directing the arrest of a person charged with a crime will be in the possession of the officer when he makes an arrest under it, for he is required to exhibit it, if called upon to do so, and this is based on a wise public policy. One purpose of which is that the officer may have to exhibit such evidence of his authority to make the arrest as will be deemed sufficient to take from the person whose arrest is commanded all right to question the authority of the officer. Point 2z. The argument that officers are free to arrest because there is a warrant outstanding, is nullified by the requirement of law that one arresting under a warrant must show it if requested to do so, which is manifestly impossible unless he has the warrant in his possession. An officer arresting for taxes due on a tax warrant was held to be a trespasser where he had not the warrant with him at the time of arrest, thus failing to show it to the one arrested. The court unanimously held, "We think the authorities are all to the effect that the officer making the arrest must be in a situation to show, if required, the authority under which he is acting. It is the legal right of the citizen when arrested that such shall be the situation, and, therefore, when such situation does not exist the arrest is a legal wrong." 23. 22 Cabell. Arnold, 86 Texas 102, 23 SW 645, 646, 1893. An arrest warrant is to be shown to the accused for he has a right to see if it is a valid warrant. Speaking on the topic, production of warrant, one law textbook states, "Every person relying upon a warrant in making an arrest should read it if requested so to do. Where a warrant is necessary but the person making the arrest refuses to exhibit it when called upon to do so he may forfeit the protection which it otherwise would afford him." 24. In the Annotation of American Law Reports, Vol. 40, p. 62, a review was given on the topic, necessity of showing warrant upon making arrest under warrant. The report clearly showed many other cases that held that the officer must show the warrant upon request, and stated. The weight of authority now, however, seems to support the proposition that an officer making an arrest under a warrant should show the warrant, if requested to do so, and in some jurisdictions he is expressly required by statute to do so. 25. The enactment of a statute that the warrant is to be shown upon arrest is but declaratory of the due process procedure that must be followed in an arrest. Thus no statute is needed, and where it exists it is merely redundant in nature. The annotated report did speak of some authorities where it appeared that the failure of showing the warrant was allowed. It stated in the review that in some cases, a regular officer does not need to show his warrant before making an arrest thereunder. Such cases involved the question of whether the officer is known or unknown to the person. 23 Smith v. Clark, 53 NLL 197,21 Atlantic 491, 1891. Citing Webby. Slate, 51 N.L. Law 189, 17 Atlantic Republic 113. 24-2 Ruling Case Law, Arrest, 23, pages 465-66. 2540 American Law Repons, annotated, p. 66, numerous cases cited. Arrested. In some cases it was stated that the officer is known, he need not show the URDTB or the arrest, but must show it. NTB arrest. And where the officer is % known, he is to show the warrant before TB used. Other cases where it appeared that the ring of the warrant was not needed is ere resistance is offered or threatened. For the person asked to see the warrant. The argument that a known officer need liable display his warrant at all, or that in lieu of displaying it need only state the authority under which he is acting, is not justified by AE principles for why warrants are needed in J.E. first place. Such an argument could completely take away most of the safeguards of liberty which the requirement for a warrant has established. The true law on the matter requires the officer to possess and display the errant whether B is known or not, and in addition to his stating the nature and cause for B arrest. The generally recognized rule, however, sustained by the weight of authority and particularly in cases of misdemeanors, requires the officer to exhibit the warrant of arrest before the arrest is made, unless there is some resistance. 26. In an English case cited in 40 ALR, annotated, it was held that where a constable making an arrest did not have the warrant him, he was not justified in making the arrest. The court said, "We have already expressed our opinion that, if requested, the officers are bound to produce the warrant, and, if so, the keeping in custody after request and non-compliance would not be legal. And it can hardly be contended that the arrest itself could be legal. 21. 45. In an older English case, it was said that the doctrine that an officer need not show his warrant was a dangerous doctrine. The court also stated, "I do not think that a person is to take it for granted that another who says he has a warrant against him, without producing it, speaks truth. It is very important that, in all cases where an arrest is made by virtue of a warrant, the warrant, if demanded, at least, should be produced. 28. The reason for the duty of an officer arresting a party by virtue of a warrant was declared in Commander v. Cooley, 6 Gray, Massachusetts. 350, 1856, as being to explain the cause for which he makes the arrest, to state the nature and substance of the process which gives him the authority which he professes to exercise, and, if it is demanded of him, to produce and exhibit it to his prisoner for his perusal, that he may have no excuse for resistance." The court added that the SE are obviously successive steps, which cannot all occur at the same instant of time. In a New York case, a man was convicted for resisting a police officer who attempted to arrest him for a past misdemeanor, the warrant being at his office. His conviction was reversed because it was the duty of the officer, at the time of the arrest, to disclose to the defendant his authority and the process under which he was to be arrested. The court said the state statute was the same as the common law doctrine on this matter. If the officer must show the warrant, if required, then it is plain that it must be in his actual possession. It would be absurd to construe this to mean that after making the arrest the officer must, if required, take the 26 Walter H. Anderson A Treatise on the Law of Sheriffs, Coroners and Constables, Vol. 1, I-34, p. 131, 1941. 1748.Lr.67, citing, G. A. Ward v. Loxton, 2 Best and S. 363, 121 ENG Reprenel, 1109, 1862. Also in 51 LRA 202. 2340 ALR 67, citing, Have. Roche, ATR 187, 101 ENG reprint, 1337, 1799. 46. Defendant to some other place and there show him the warrant. It is clear that the warrant must at the time of arrest be shown, not at a later time. In Stair v. Finney, 42 Me 384, 1856, the court, in discussing authorities, stated that it is very important in all cases where an arrest has been made by virtue of a warrant, that the warrant should be produced if demanded. In Chauvelin v. Com 106 PA 369, 5 am. Crim. Republic 41, 1884, the court, in explaining the duty of one making an arrest, said, it is doubtless the duty of an officer who executes a warrant of arrest to state the nature and substance of the process which gives him THC authority he professes to exercise, and, if it is demanded, to exhibit his warrant. That the party Arstead may have no excuse for resistance. In J. Alls v. State, 114 GA 79, 39 SE. 1901, the state Supreme Court held that a constable was not justified in attempting to arrest the defendant under a warrant which was in TB sheriff's hands. The court said that, it was the duty of an officer who attempts to make an arrest exhibit the warrant if he has one. Invalid and unlawful warrants. A warrant must have certain requisites in order to render it valid and available as a defense. Many unlawful arrests have been made due to warrants' failure to meet such requisites. Whenever a warrant is invalid on its face, or where it is only a summons, the officer arresting the defendants will be liable in 29 POP/V Shanley, 40 Hun 477. 478, NY 1886. Damages. 0. A prima facie invalid warrant will be regarded as no warrant and the officer making an arrest by a void or invalid warrant is not protected by it. Process that is void on its face is no protection to the officer who executes it. If a warrant, order, or writ of possession shows lack of jurisdiction of the court, the officer is not protected in serving it. In fact, in so doing he becomes a trespasser. 1. A constable justifying an imprisonment under a warrant must show that the warrant on its face is legal, and that the magistrate had jurisdiction of the subject matter. Why both a proper subject matter jurisdiction and geographical jurisdiction are necessary for a valid warrant. It is generally held that where the court has no jurisdiction the officer executing a warrant will be liable in damages. The question of jurisdiction can be raised at any time. And since neither consent nor waiver can give jurisdiction, the court will not proceed where it appears from the record that it has no authority. A warrant for the arrest of an alleged fugitive was void because the complaint did not state that the original charge has been made upon oath, or made to a court, and it afforded no protection to the constable. 34. The requirements of what a warrant should contain depends primarily on constitutional mandates, due process practices and common law principles. The common law requires that an arrest made OD a warrant be issued only after a formal 3051 LR. A 197. Citing Frazier v. Turn R. 76 Wisconsin 562, 45 NW 411, Carrot v. Morley, 1 QB 18, 1 Gale and 045. I-70 American Jurisprud NC, 2D Ed Sheriffs, Police, and Constables, 165. pp. 2 Law U. R. Pons Analod, Vol. 51, p. 197, citing, Polk v. Slocum, 3 Blackville Roads, IND, 42133 SMU Ekinlu Risprud NA, 2D Ed, Arrest, 7, p. 700. 34 Lawyers are pawns annotated, vol. 51, p. 197. Citing Forbes v. Hicks, 27 Nebraska 111, 42 NW 898, 1889. Charge is made under oath. 5 Thus no arrest is, unless based upon a sworn affidavit. An affidavit that does not appear to have been sworn before any judicial officer, and a warrant signed only by the officer who made the arrest and not dated or authenticated. Afford no lawful authority for the arrest and detention of an accused. 36. Another obvious requirement of a warrant would make it void on its face as if it is not signed by a magistrate or justice of the peace. It has become a practice in some areas to have errants rubber stamped with the judge's name. This stamping being done by some clerk or administrative employee. This blatantly unlawful practice has been adopted for convenience sake, which is the most common reason or excuse government uses to transcend constitutional limitations. Such limitations /IO are designed to make government follow certain established procedures and thus make things difficult in order to deprive a citizen of his liberty or property. A rubber-stamped warrant is invalid on its face as it is not signed by any judicial officer. The authorization for a warrant requires not only judicial authority but is to be done by one who is learned in the law to detain if probable cause exists to issue the warrant. In Minnesota, the state Supreme Court held that a statute permitting clerks and deputy clerks of the county municipal court to receive complaints and issue warrants in 35 MO. Slate, 140 Nebraska 592, 300 NW 843. S45, 1941. 47. Prosecutions under municipal ordinances is unconstitutional. The court said. The United States Supreme Court has considered and disposed of a related problem in Camara v. Municipal Court, 387 U.S. 523. 541. The majority in Camara nevertheless stressed the need for individualized review by a neutral magistrate to avoid the issuance of rubber-stamp warrants. Since the taking of an affidavit in a criminal proceeding imposes a duty of a judicial nature, an affidavit taken before a clerk or prosecuting attorney is not sufficient as a basis for the issuance of a warrant. J.S. A warrant is regarded as insufficient and thus void if, on its face, it fails to state facts sufficient to constitute a crime. Also, a designation or description of the offense should be written in the warrant, but need not be specified with the same technical strictness that is required in an indictment. 4. The rule on sufficiency of a charge on which a warrant can issue is stated as follows. The complaint or charge on which a warrant is issued must set forth the facts constituting the offense on the knowledge of the person making the complaint. And if docs not know them, other witnesses must be examined who do know them, and no person can be arrested on the mere belief of the person making the complaint. A warrant issued for a matter that is not a criminal offense is no justification for a constable who arrests upon it a person. 36 Liberis v. Harper, 89 FLA 477, 104 So. 853, B55, 1925. Also C5 AM Jur. 2 D. Russell, 12, p. 705. L7 Stalt. V. Pollock, 277 Minnesota 140, 151 N.W.2 D. 591. Also, Cox v. Perkins, 107 SE 863, 865, GA 1921. 38 COXL. Perkins, 151 GA. 632, 107 SE 863, 1921. 39 Warden's Criminal Procedure, J2TH ed., Vol. I, 54, p. 152, 1974. Siling, Go Ban Importing Co. v. Unalt, D. Stat S. 282 U.S. 344, 355, 1930, X. Payne Burford, 7 U.S. 44b, 451, 1806, Smith v. Clark, 37 ULA 116, 106 Pac. 40 Def v. Commonwealth, 166 Kentucky 39, 178 SW 1129, 1915, Moser v. Folk, 237 NC 302, 74 S.E.2D 729. 41 2 RCL Arrest, 17, p. 460, Seiling Brown v. Hedwin, 182 Michigan 491, 148 NW 693, 1914. 48. Cannot be lawfully arrested by a sheriff acting under a copy of a court order or warrant in the form required. 42 Such copy is not valid. Inaccuracies and imperfection do not vitiate a warrant which substantially charges an offense. But where a complaint, recited in substance in a warrant, is verified merely on information and belief and does not state facts sufficient to constitute an offense, the warrant must be held to be invalid on JTS face. 43 Also, an affidavit that merely states belief in the guilt of the accused is insufficient to support a warrant of arrest. 44. The Supreme Court of Kansas said that a warrant cannot be issued which is verified on the county attorney's hearsay and belief. If a warrant, in the first instance, may issue upon mere hearsay or belief, then all the guards of the common law and of the Bill of Rights, to protect the liberty and property of the citizen against arbitrary power, are swept away. 45. An affidavit based upon a presumption or belief of crime does not give jurisdiction to the court to issue a warrant, and at common law, a constable or sheriff cannot execute a warrant outside their jurisdiction. To summarize, the following are the basic requisites needed to make a warrant valid. A warrant is to be issued by a judicial officer and signed by him. It must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. It cannot be based upon belief or suspicion, but upon probable cause. The warrant is to list a complaint which is to state the offense committed and the facts that constitute a crime. A warrant is to be supported by a signed affidavit made under oath by the person making the charge. It must truly name the person to be arrested, or describe him sufficiently to identify him. The warrant must also command that the defendant be arrested and brought before the nearest available magistrate. The officer is bound to know if under the law the warrant is defective, and not fair on its face, and he is liable as a trespasser, if it does not appear on its face to be a lawful warrant. His ignorance is no excuse. 47 The typical form of a warrant is like this. Municipal Court, Springfield Judicial District. To any peace officer of the realm of jurisdiction upon signed oath having been brought before me that the crime of larceny has been committed, and accusing John Smith of the same. You are hereby commanded forthwith to arrest and bring that person before me. Bail may be ad me head in the sum of $1,000. Dated, May 15, 1997/S/Bill Wright, Presiding Judge. Every citizen should, when arrested, or at trial, request to see a warrant and check that it meets required criteria and object if it does not. Point out that the arrest is unlawful and how the warrant is defective. Such vigilance is necessary to secure liberty and to stop unlawful and oppressive measures from continuing in government. 42-5 American Jurisprudence CT, 2D ed., Arrest, 7, p. 700, Citing, Layton v. Hall, 31-3. 43-5 American Jurisprudence, 2D ed., Arrest, 8, p. 702. 44 Jardendlo v. United States, 357 U.S. 480, 78 Sup. CT 1245, 1957. 45 The Sile 1. Gleason, 32 Kansas Republic 245, 251, 1884. 4661 American Law Reports, annotated, Prince 377-379, Hausch 1. People, 75,111. 47 Tiedemann, Limitations of Poliet Power, p. 83, Citing, Grumman v. Raymond, 1 Con 39, Clayton v. Scott, 45 VT 386. 49. 7. Bringing arrested person before a magistrate. Duly of officer. It is a fundamental rule of procedure well grounded in the common law. that where an arrest is made the alleged offender is to be taken before a magistrate to be dealt with according to law. 1. This is not only to be done, but done without delay, or without unnecessary delay, otherwise the arresting party is liable for a false imprisonment. In Blackstone's Commentaries, Volume 4, Chap XXI, p. 292, it was stated that a constable may, without warrant, arrest any owed for a breach of the peace committed in his view, and carry him before a justice of the peace. The officer must bring a person he has arrested directly to a magistrate, otherwise it is a breach of duty. It is to be duty of an officer or other person making an arrest to take the prisoner before a magistrate with reasonable diligence and without unnecessary delay. And the rule is well settled that whether the arrest is made with or without a warrant, an action for false imprisonment may be predicated upon an unreasonable delay in taking the person arrested before a magistrate regardless of the lawfulness of the arrest in the first instance. Thus, even if the arrest was lawful, a failure to take the person arrested to a magistrate will be regarded as unlawful imprisonment, as the Supreme Court of Minnesota held. Even though an arrest be lawful, a detention of the prisoner for an unreasonable time without taking him before a committing magistrate will constitute false imprisonment. In an exhaustive decision on the common law rule of the process and procedure for arrests, the Supreme Court of Mississippi, in the case of Orrick v. State, said, by the common law of England an arrest without warrant for a felony can be made only for the purpose of bringing the offender before a civil magistrate. 4. This procedure is the due process of law and be followed in depriving one of his libe. Thus a failure or even a delay in following this process is an unlawful restraint or deprivation of liberty and thus a type of false imprisonment. The arresting officer has no authority to take a person to a jail and detain him there. His duty is to take the one arrested without delay to a court or magistrate, as said by the Supreme Court of Kansas. Muscoev. Como fue al 86 Virginia 443, 447, 10 SE 534, 535, 1890. 2 Mullins L. Zonters, 189 Virginia 624, 54 S.E.2D 116. 120, 1949, citing, 22 AM. Jewell, False Imprisonment, 20, p. 366, 35 CLS, False Imprisonment, 30.31. pp. Also, P. Hum v. Werflow, R. Brothers Pickler S., 36 calories app.2D 214, 97 Pacific 2D 472, 474, 1939, Oxford I. Berry, 204 Michigan 197, 170 NW 83, 88, 1918. 3 Clydon v. Glasscock, 215 Minnesota 417, 10 N.W2D 394, 397, 1943. 4 Orrick v. Slate, 140 Miss 184, 105 So. 465, 470, 1925, citing. Kurtz v. Mofil, 115 U.S. 487, 499, J88S. 50. The law contemplates that an arrest either by an officer or a private person with or without a warrant is a step in a public prosecution, and must be made with a view of taking the person before a magistrate or judicial tribunal for examination or trial. And an officer, even, subjects himself to liability if there is an unreasonable delay after an arrest in presenting the person for examination or trial. S. The only reason that can justify having an arrested person in jail or detained by the arresting officer, is as a necessary step in bringing him before a magistrate, as so stated by the Supreme Court of Rhode Island. When an officer makes an arrest, without warrant, it is his duty to take the person arrested, without unnecessary delay, before a magistrate or other proper judicial officer having jurisdiction, in order that he may be examined and held or dealt with as the case requires. But to detain the person arrested in custody for any purpose other than that of taking him before a magistrate is illegal. 6. Thus detainment in a jail for purposes of booking or fingerprinting or investigating the alleged crime, or interrogation of the prisoner is illegal. In cases involving the commission of the most severe crimes, as in felonies, the one arresting is still required, without unnecessary delay, to bring the prisoner to the nearest magistrate or court as a matter of fundamental law. From the earliest dawn of the common law, a constable could arrest without warrant when he had reasonable grounds to suspect that a felony had been committed, and he was authorized to detain the suspected party. 5 Gamia vis Quins, 62 Can. 321, 62 Pac. 6 Komenskaya. Durand, 64 Ri 387, 12 ATI.2D 652, 655, 1940. Such a reasonable length of time as would enable him to carry the accused before a magistrate. And this is still the law of the land. The court went on to state that the officer making the arrest is liable for false imprisonment if he arrests with the intent of only detaining, or if his unreasonable delay causes a detainment. On pg 1092 it stated, "It cannot be questioned that, when a person is arrested, either with or without a warrant, it becomes the duty of the officer or the individual making the arrest to convey the prisoner in a reasonable time, and without unnecessary delay, before a magistrate, to be dealt with as the exigency of the case may require." The power to make the arrest does not include the power to unduly detain in custody, but, on the contrary, is coupled with a correlative duty, incumbent on the officer, to take the ACC used before a magistrate as soon as he reasonably can. Authorities cited. If the officer fails to do this, and unreasonably detains the accused in custody, he will be guilty of a false imprisonment, no matter how lawful the original arrest may have been. Citing, 1 Hill. Torts, pages 213-14, section. Thus, where a person arrested is taken to a jail or sheriff's office and detained there, with no warrant issued before or after the arrest, it is false imprisonment. The one arresting has a duty to immediately seek a magistrate, and that the failure to do so, makes a case of false imprisonment, as a matter of law, is held by all the authorities. 8. In a case involving an indictment for assault and false imprisonment, the Supreme Court of North Carolina held that in the process of a lawful arrest, the one arrested is to be taken immediately to a judge. Authorities cited. 7 Kirk. Garrell, 84 MD 383, 40607, 35 et. 8 Heath v. Boyd, 175 S.W.2D 214, 217, Texas 1943, Brock 1. Stimson, 108 Mass. He question occurs, what is the officer to do with the offender when he shall have been arrested without warrant? All the authorities agree that he should be carried, as soon as conveniently may be, before some justice of the peace. 9. Though this case involved an arrest. Though all warrant, the court said it is the duty of the arresting officer upon making an arrest, whether with a warrant or without one, to carry the offender at once before a justice. To take an arrested person to a jail to be detained and fingerprinted is a violation of his rights. It is proof the officer had no intent to bring the accused directly to a judge. In Anderson's treatise on the law of sheriffs, the subject of an officer's duty after arrest was examined with this conclusion. It is the undoubted right on the part of a prisoner, on being arrested by a public officer or private citizen, and unquestionably a corresponding duty on the part of the one making the arrest, to take the prisoner before a court or magistrate for a hearing or examination, and this must be done without unnecessary delay. The object of this right and corresponding duty is that the prisoner may be examined, held, or dealt with as the law directs and the facts of the case require. It is highly improper and an invasion of the lawful rights of the prisoner to take him to any other place than to a proper court or magistrate. 2. In deciding the proper duty and action of an arresting officer after making an arrest, the Supreme Court of Appeals for Virginia stated that the right of the accused to prompt judicial examination does not depend upon their statute law. 9S/OV Frufflin, 86 NC 683, 685-86, 1882. But even if the circumstances of the arrest were not within the purview of this particular statute, it was the duty of the arresting officer to have taken the defendant within a reasonable time, or without unnecessary delay, before a judicial officer in order that the latter might inquire into the matter and determine whether a warrant should be issued for the detention of the defendant, or whether he should be released. LL. 51. And, in speaking on what manner of arrests were lawful at common law, and what are the procedures under the common law when an arrest is made, the Supreme Court of Rhode Island held that, coupled with the authority to arrest went an imperative obligation on the officer to bring the arrested person before a magistrate without reasonable delay. Especially was this true where the arrest had been made without a warrant. When an officer makes an arrest, without warrant, it is his duty to take the person arrested, without unnecessary delay, before a magistrate or other proper judicial officer having jurisdiction, in order that he may be examined and held or dealt with as the case requires, but to detain the person arrested in custody or any purpose other than that of taking him before a magistrate is illegal. This rule of law requiring an officer or person arresting to bring the party arrested before a magistrate is the same in all states and cannot be abrogated by statute. The same rule has been upheld in federal courts, and is prescribed under Title 18 in the Rules of Criminal Procedure. An officer making an arrest under a warrant issued upon a complaint, or any person making an arrest without a warrant, shall take the arrested person without unnecessary delay before the nearest. 10 Walter H. Andon, A Treatise on he law y sheriffs, Courant and Constables, Vol. I, 17980, 1941. 2 Evans on I. Common Talha, 188 Virginia 386, 49 S.E.2D 611, 615, 1948. Authorities cited therein. 12 Kaminsky v. Durand, 64 RT 387, 12 ATL 2D 652, 654, 1940. Authorities cited therein. 52. Available federal magistrate. Or in the event that a federal magistrate is not reasonably available, before a state or local judicial officer authorized by 18 VSC 3041.0. In a federal case where a man was arrested by 2 FBI agents assisted by 2 local policemen on an outstanding warrant for bank robbery. The agents placed the man in a police vehicle, drove a few blocks, and then parked on the street under a street lamp. The officers interviewed the man concerning the crime and within a few minutes he confessed to the crime. The Federal Court of Appeals said the confession was inadmissible and reversed his conviction. As the momentary parking of the police vehicle en route from the place of arrest was a detour from the path toward a prompt presentment before a magistrate. The court stated, the law requires an arresting officer to bring an accused before a magistrate as quickly as possible. Cases cited. The rights of the accused were violated as he was not promptly taken before a judicial officer as the law required, but instead was questioned while held in custody. It is said that police are guilty of oppression and neglect of duty when they willfully detain a prisoner without arraigning him before a magistrate within a reasonable time. In a case where a person sued for being arrested without warrant and confined in a jail without examination before a court or magistrate, it was found on appeal that such 1318 USCA Rules of Criminal Procedure, Rule 5, p.29. 14 Grunwald v. United States. 336 FCD.2D 962. Action was unlawful, and TB Supreme Court of Illinois held. We are of opinion, the arrest of the plaintiff was illegal, and the verdict contrary to the law and the evidence. And if the arrest was legal, they did not proceed according to law, and take him before a magistrate for examination, but conveyed him to another county, and there imprisoned him in the county jail, in a filthy cell, thus invading one of the dearest and most sacred rights of the citizen, secured to him by the great charter of our land. Kindred v. Stilt, 51 ill. 1869. The requirement of bringing an arrested person directly to a court or judge is due process of law, and as such this procedure cannot be abrogated by statute. As a trespasser ab initio. It is a familiar rule of law that one who abuses an authority given him by law becomes a trespasser ab initio. 17 That is, he becomes a wrongdoer from the beginning of his actions. Where ode fails to take a prisoner he has arrested to a proper judge, or where he causes an unreasonable delay in doing so, the officer becomes a trespasser ab initio. 18 The unlawful confinement by an officer makes the entire transaction, including the arrest, unlawful and a trespass. Thus even in cases where an executive officer had made a lawful arrest, if he fails to 15 People v. Mumiani. 258 NY 394, ISON pound 94, 96, 1932, Peckham v. Wilmer Brothers Pictures, 36 calories app. 2D 214, 97 Pacific 2D 472, 474, 1939. 16 For other cases on this matter see, Judson v. Reardon. 16 Minnesota 387, 1871, Long v. Thislow, 12 GA 293, 318, 1852. Moses v. State, 6 GA App 251, 64 SE 699, 1909. Heifel. Smith, 59 SE 475, Virginia 1907, Folsom v. Japer, 192 Iowa. 1056, 186 NW 28. 29, 1922, Poundge v. Burt. 96 MD 715, 54 986,988, 1903, Bryan v. Comstock, 220 SW 475. 17 LQ, TR v. Waffle 62 Ohio 51. 500, 57 NE 506,508, 1900. 18 Great American Indemnity County v. Beverly, 150 Aesop. Mg The arrested person to a magistrate Helixcoides a trespasser a benerio and liable. An officer, who has lawfully arrested a prisoner, may be guilty of false imprisonment if he holds him for an unreasonable length of time without presenting him for hearing or procuring a proper warrant for his detention. 3. The New York Supreme Court of Appeals stated to be correct exposition of the law in a case. Barrett said that even though the arrest been made, was legal and justified, the officers became trespassers ab initio and so continued to the time of plaintiff's release because of their failure to take him before a magistrate as required. 20. And TB Court of Claims of New York, in a case where the officers delayed in the claimant's arraignment, held that if there was an unnecessary delay in arraigning the claimant before a justice of the peace 1, then the arrest itself became unlawful on the theory that the defendants were trespassers ab initio and so continued down to the time when the plaintiff was lawfully held under a warrant of commitment. Regardless of whether or not the plaintiff was guilty of any error. Numerous cases cited. In Pastor v. Reagan, Supra, it is said that, the rule laid down in the Six Carpenters case, 8 Coke, 146, that if a man abuses an authority given him by the law he becomes a trespasser ab initio, has never been questioned. Where one was arrested for being intoxicated and confined in a prison without judicial inquiry, it was held to be a wrongful. 53. Imprisonment. On this matter the Supreme Court of Washington stated, nor is a police officer authorized to confine a person indefinitely whom he lawfully arrested. It is his duty to take him before some court having jurisdiction of the offense and make a complaint against him. Any undue delay is unlawful and wrongful, and renders the officer himself and all persons aiding and abetting therein wrongdoers from the beginning. 22. Thus when one fails to perform part of his duty and it impinges upon the rights of a citizen, he is said to be a trespasser from the beginning because his whole justification fails. And he stands as if he never had any authority at all to act. Detainment is not a decision of arresting officer. The basis of the well-established procedure in law of taking a person arrested directly to a judge or court, is to avoid having the liberty of the citizen unjustly dealt with by extrajudicial acts of executive officers. We believe that fundamental fairness to the accused requires that he should with reasonable promptness be taken before a magistrate in order to prevent the application of methods approaching what is commonly called the third degree. Fundamental fairness prohibits the secret inquisition in order to obtain evidence. Other reasons for the purpose of this rule requiring that the arrested accused be taken before a magistrate as quickly as possible, is 10. 19 Thomas Cooley, A Treatise on the Law of Tons, VOT. 1J14, p. 374, numerous aut horitis cited therein. 20 Farina I. Saratoga Harness Racing Association, 246 N.Y.S.2D 960, 961, 1964. Seguin v. Mayan, 108 N.Y.S.2 D28,30, 1951. 21 BL$V.S. Tate. 92 N.Y.S.2 D42, 46, 47, 196 Miscellaneous. 22 Ulves ad v. Dolphin Atah, 152 Washington 580, 278 Pack. 23 Brock v. Stimson, 108 Massachusetts 520, 1871, Authorities Siled, Hegirv. Hunt, 129 Me 10, 112 A 675. 24 State F. Schubert, 15 NW.2 D 585, 588, Minnesota 1944. Also, Floyd v. Chesapeake and Oricio, 164 SE 28,30, West Virginia 1932. U.S. v. Middleton, 344 Federal 2D 78, 82, 1965. 54. Make certain that the person arrested is advised by a judicial officer of his constitutional rights. 2J. This is a duty of the officer through the erroneous Miranda warning. The only reason such warnings are being used is because police are not doing their duty in bringing the person arrested to a judicial officer, but instead are unlawfully taking them to a jail to have them booked. The detainment of a person after he is arrested is a judicial question. A judicial officer must decide if there are grounds for holding the person arrested, or whether he must be further examined by trial, or if he is to be bailed and released. To allow the executive department such powers of decision-making is the epitome of despotism. In a suit for false imprisonment where several officers arrested the plaintiff on grounds he committed a felony, the Supreme Judicial Court of Massachusetts held the officers had no right to decide to detain the plaintiff to enable them to make a further investigation of the charge against him. The court declared that, but having so arrested him, it was the officer's duty to take him before a magistrate, who could determine whether or not there was ground to hold rum. It was not for the arresting officers to settle that question, authorities cited. The arresting officer is in no sense his guardian, and can justify the arrest only by bringing the prisoner before the proper court, that either the prisoner may be liberated or that further proceedings may be instituted against him. 26. In a case where one was accused by another of stealing a watch, and subsequently arrested and put in jail for 1 hour and then released, the sheriff was found guilty of false imprisonment as he failed to take the person arrested before a magistrate. The Supreme Court of Indiana upheld the conviction, stating that the power of detaining a person arrested, or restraining him of his liberty, is not a matter within the discretion of the officer making the arrest. The court further stated that the sheriff cannot legally hold the person arrested in custody for a longer period of time than is reasonably necessary, under all the circumstances of the case, without possessing a proper warrant or taking him before a magistrate. If he does, it is false imprisonment. Thus, where a sheriff had arrested 2 prisoners and detained them for 5 hours without making any effort to take them before a magistrate, he was guilty of false imprisonment. In this case, the Supreme Court of Idaho said, the rule seems to be that an officer arresting a person on criminal process who omits to perform a duty required by law, such as taking the prisoner before a court, becomes liable for false imprisonment. The law never allows an officer at his discretion to imprison the person arrested or detain him in a jail after arrest. We have no doubt that the exercise of the power of detention does not rest wholly with the officer making the arrest, and that he should, within a reasonable time, take the prisoner before a circuit, criminal, or other judicial court. In a case where the arrest is made under a warrant, the officer must take the prisoner, without any unnecessary delay, before the magistrate issuing it, in 2 Scriptural Unjate Stats, 336 Federal 2D 962, 966, 119 U.S.App.D.C. 43, 1964. 26 K. Uft v. Hart, 213 Massachusetts 476, 100 NE 558, 559, 1913. 27 Hams S. STTET, 64 NE 875, 878, 1902. Also, Strom R.G. Hanston, 177 Minnesota 307 225 NW 148, 149, 1929. 28 Madstone v. Hutchison, SHTN/TTL 49 Idaho 358 290 Pacific 208, 209, 1930, numerous cases cited. Ord are that the party may have a speedy examination, if he desires it, and in the case of an arrest without warrant the duty is equa lly plain, and for the same reason, to rake the arrested party before some officer. Bo can take such proof as may be a fo rd ed. Point 29. Executive officers or clerks are not to determine if a person arrested is to be held or released upon bail, or fix the amount of bail, since the power to do so is judicial. 3.0. In a case where a person was lawfully arrested for driving an automobile while intoxicated, the arresting officer delivered him to the jailer at 4:30 p.m., with the instruction that he be held there until 9:00 p.m., at which time he was to be brought before the judicial officer. The Supreme Court of Appeals of Virginia condemned this act, asserting that the officer usurped the functions of a judicial officer. But the actions of the arresting officer and the jailer in denying the defendant this opportunity to judicial review by confining him in jail because they concluded that he was not in such condition to be admitted to bail, had the effect of substituting their discretion in the matter for that of the judicial officer. Under the circumstances bare, the defendant was clearly entitled to the benefit of a judicial opinion and judgment upon the question of his eligibility for bail. This right was arbitrarily denied him. Executive officers cannot hold a person in order to complete paperwork or make out reports. Thus where a man was arrested 55. Without warrant and confined in the county jail without a commitment, the sheriff could not justify the confinement of the man by awaiting the pleasure of a deputy, or anyone else, to file a complaint. 32. The power of the executive officer over a person's liberty ends with the lawful arrest, and he never has a discretionary power to detain the person without judicial authority. If the plaintiff was being detained for the purpose of arrest, it was the duty of the arresting officer to take him before an examining magistrate as soon as the nature of the circumstances would reasonably permit. The power to arrest does not confer upon the arresting officer the power to detain a prisoner for other purpose. S.L. Arresting and releasing without bringing before a judge. While most of the emphasis on this type of false imprisonment deals with the delay in presenting a prisoner to a judge, the real duty and requirement is the actual bringing, carrying or presenting the prisoner before a judge. Thus a complete failure to do this is obviously unlawful, and this most often occurs when the officer releases the person he arrested without judicial presentment. An officer who arrests an individual does not have the authority to place such person in a jail, or other holding place, and then later release him. As was revealed in the case of Harness v. Sleely 34, where the sheriff placed the person arrested in jail for an hour and then 29 Simmons v. Van Dyke, 138 IND 380, 37 NE 973, 974, 1894, citing, ex Barracubril, 49 calories 436, 1875, Pratt v. Hill, 16 Barb. NY, 303, 307, 1853, ETL. 30 Bryant I. City of Bisbee, 28 Arizona 278, 237 Pacific 380, 381, 1925, Slady I. Miller, 31 Texas 564, 565, 1869. 1 Winsland v. Commonwealth, 188 Virginia 386, 49 S.E.2D 611, 615, 1948. 32 Bowles v. Creason LAF, 156 Oregon 278, 66 Pacific, 2D, 1183, 1188, 1937. H. Golden v. Finnegan LAL, 213 Wisconsin 539, 252 NW 369, 372, 1934. 3464 NE 875, 878, 1902. 56. released him without bringing him before a justice of the peace. He was thus guilty of false imprisonment. H has become a common practice for arrested persons to be taken to a jail or police station to be booked, fingerprinted, photographed, measured, questioned, imprisoned and then released after paperwork is completed. This wicked and oppressive procedure is so far removed from what due process of law requires, it is shocking that such measures could be widely accepted as legal. The process of imprisonment and release at the discretion of the executive officer was condemned by the Supreme Court of Illinois in stating, when officers assume the power to imprison without authority of law, or without any forms or processes usual and necessary to be employed, they become liable for false imprisonment. The liberty of the citizen cannot be so far trifled with, that any constable in the land may of his own volition, commit and hold him in custody until it suits his convenience or pleasure to release him. Js. When a constable or sheriff decides to release the person arrested without taking him before a magistrate, he assumes judicial powers upon himself and is liable. Thus where a town constable arrested a person who was intoxicated, and imprisoned him in lockup until he became sober and then released him without taking him before a magistrate, he acted unlawfully and is liable. In this case the Supreme Court of North Carolina stated, men may not be arrested, imprisoned, and released upon judgment or at the discretion. 35 People v. McGurn, 341,111. 632,173 NE 754, 757, 1930. 36 Sum v. Parker, 75 NC 249, 25 U, 1876. Of a constable or anyone else. If the alleged offense be criminal in its character, the officer may arrest and take the offender before a magistrate for trial. The constable arrested and imprisoned him, not for safekeeping until BC could be tried before a competent tribunal, but he imprisoned him until BC became sober, according to his judgment, and then released him. The constable thus constituted himself to be judge, jury, and executioner. This is the best description of despotism. J6. When an officer institutes an arrest, he now has undertaken the duty to bring the arrested party to a magistrate. The person can only be released by judicial, no, executive authority. The duty of the on making an arrest to bring the prisoner before a proper magistrate, that proceedings for the trial of the prisoner may be instituted and that he may have an opportunity to give bail or otherwise procure his release, is even more imperative than if a warrant had been issued before arrest, and if the prisoner is released without being brought before such magistrate, the officer or private person who made the arrest becomes a trespasser ab initio. Arresting a person is a step in prosecution, and if he is released not according to law, it is an escape. Such an escape is a deparure of a prisoner from custody before he is discharged by due process of law. 38 If a person is arrested pursuant to a warrant, b. must be taken to a magistrate before he can be released. 1 Warden, CRPROC, 195. In deciding if a chief of police acted properly when he put two individuals he. 3711 Ruling Case Law, False Imprisonment, 15, pages Sol 02. See also, Williams v. Zelza Warehouse, 126 Cal.App. 28, 14 Pacific, 2D, 177, 178, 1932. 38 Heffler v. Hunt, 120 Me 10, 112 A 675, 677, 1921. At SLED in jail overnight, and releasing them clear depositing bail, the Federal Court of S said the actions of the officer in this 2SC were arbitrary and unjust. The police MF had no right to determine bail and then the prisoners without a hearing before a G, the court said. In an able opinion, E.T. Payne Harvin 267 F. 997, 1003, Judge Connor SAID, the imprisonment in jail of a citizen without errant, without opportunity for a hearing or to give bail, is a serious matter. The duty in every ease is imperative upon the officer to forthwith carry the person arrested before the nearest judicial officer having jurisdiction to hear and determine the legality of such arrest. E.T. Part Van Hoven, Federal Ca. Number 16858 and 25 CJ. 491 and 493. The general rule is stated as follows: 1. Making an arrest may be liable in an action for false imprisonment where he fails to take the person arrested before the officer designated in the warrant, or if the arrest is made without warrant, to the nearest committing magistrate. J9. If a prisoner accepts his release or is released at his request or with his consent, he does not waive his right of action. To say be bas no right to sue under such conditions, is allowing a situation that is susceptible of working great injustice. Where a person is unlawfully detained, he has a right of action irrespective of his release. 40. Defenses. Just as good faith does not excuse an unauthorized arrest, likewise, it does not justify an unreasonable detention and deprivation of one's liberty caused by a 57. Failure or delay in bringing one arrested before a magistrate. 41. It has been a common practice for officers to drop off persons they have arrested at a police station or county jail and leave the prisoner in the custody of others. This is a very dangerous and irresponsible act for an officer to follow. In doing so, the arresting officer relinquishes his duty and at his risk relies on others to lawfully deal with the arrested party. No officer can claim exemption from liability when he relies on others to take the arrested person before a judge without delay. He is responsible for the arrested person and cannot rely on others to perform his duty. Orders from a superior do not excuse the arresting party from his duty flow bring the prisoner before a judge. 1. Nor does delivery of the prisoner into the custody of another person. All those who take part in so detaining a person an unreasonable length of time are liable. H. The Supreme Court of Ohio had stated a similar rule. The delivery of the plaintiff, after his arrest, into custody of another person, to be by him taken top reason, could not, we think, absolve the arresting officers from the duty required of them to obtain the writ necessary to legalize his further imprisonment. If the arresting officers choose to rely on some other person 0. perform that required duty, they take upon themselves the risk of its being performed. And, unless it is done in proper lime, their liability to the person imprisoned is in no wise lessened or affected. H. 39 Moran v. Sarai of Beckley, 67 Federal, 2d, 161, 164, 1933. See also, United States v. Janus, 30 F, 2d, 530, 1929. 40 Stromberg v. Hansen, 177 Minnesota 307, 225 NW 148, 149, 1929. 41 Oxford v. Baronet RRY, 204 Michigan 197, 170 NW 83, 89, 1918. 42 Moran v. Sarai of BTC Day, 67 Federal, 2d, 161, 164, 1933. 43 Ledger v. Iveron, 62 Ohio 5 tons. 500, 57 NE 506, 1900. 58. 1/2 most common defenses raised in suits of false imprisonment of this nature involve arguments of whether the danger in bringing one to a court was reasonable or necessary. In Virginia it was said that in determining whether an arrested person has been brought before a magistrate with all practicable speed, or without unnecessary delay, depends upon the circumstances of the particular case. Ordinarily, TBS is a question for the jury unless the facts are disputed. 44. The common law principle is that an officer is to present the person arrested without delay to a magistrate. This means due delay of time is allowed which is dole incident to the act of bringing the accused to a magistrate. The cause of this breach of duty arises from the officer's total failure to act, or failure to act timely. If he does not act diligently, he may not act timely. A reasonable time is not when the officer has free time, but means promptly, immediately, and without delay, as soon as the circumstances permit. It was stated in an earlier case in New York that it was the duty of the officer making the arrest to convey the prisoner immediately before the nearest magistrate. 45. In determining whether or not an officer's failure to take an arrested man before a magistrate immediately after his arrest was an unnecessary delay, TB Supreme Court of Texas stated, "The accused has the right to be presented without delay, but the question of what is delay must be determined by all the facts and circumstances. Necessarily some time must elapse between the arrest and the presentment before the magistrate. 46. It has been the practice of legislatures and courts to establish set times of 24, 36, or 48 hours for the delay allowed from the time of arrest until presented to a magistrate. Such measures are blatant acts of tyranny, as anyone can see that if such power exists to allow a delay of 24 hours, then the power also exists to delay in 72 hours or 168 hours. The common law rule nullifies the exercise of such arbitrary power. Thus the only defense of this breach of duty is to account for the time in a delay. It has been held that a delay of from 1/2 to 4 hours in failing to take a prisoner before the magistrate arrested without a warrant, constitutes false imprisonment. 47. If an officer delays 36 hours in bringing one arrested to a magistrate, but can account for the delay of time by such reasons as bad weather, the judge was not immediately available, the one arrested needed medical attention, etc., he is not then liable for false imprisonment. But if an officer detains one he arrested for 10 minutes to see if he will confess, the officer becomes a trespasser and is liable. The liberty of citizens is too sacred to be interfered with without established sanctions by which the law guards it. But it is clear that the trend over the past 50 years has been to give police more arbitrary discretion in stopping people, making arrests, and imprisoning people. One thing history teaches us is that governments never restore lost rights and freedoms. Only citizens have ever done this. 44 Mullins v. Center. F. 189 Virginia 624, 54 S.E.2D 116.120, 1949, brought /N. Weimder and Franco, 86p.2D 79, 83, or 45 GRRTNV KRNNRDY, 48 NY Republic 653, 654, 1871. 46 Hicks v. Mutt /S, 266 S.W.2D 846, 849, Texas 1954. 47 Ujf Liams v. Stilzawarkusser, 126 Cal.App. 28, 14 Pacific, 2D, 177, 178. 59. Distortion of fundamental law. As we look at the common law principles, UD procedures for arrests which have existed are hundreds of years, as compared with the lay enforcement methods employed by most tyrannical forms of government, it is evident that we are closer to the latter. There are several reasons for this trend towards oppressive control over the citizen. Due process. Neglected due process, or the law of the land, is to act a shield against arbitrary activity of government. Since the days of King John and Magna Carta, history shows it is the firstling violated by overbearing rulers. In America, the due process provision embraces common law maxims and principles. In fact, there are many cases where the courts would cite the common law requirements for an arrest without warrant, but then would cite and follow some statute on arrest which was contrary to the common law principle. In nearly all of these cases where statutes contrary to the common law were upheld, we fail to find arguments asserting the requirement of due process of law. And in very few of them was the arrest treated as a deprivation of liberty, which cannot be done except by due process of law. This departure from the common law rule on arrest is not all the fault of the courts, but also of those unlawfully arrested for failing to raise the proper arguments in court. While there are many cases in which the arrested party has asserted the common law rule on arrest, in most, they have failed to also claim the due process clause. Without such a constitutional plea, the statute prevails. Since the time this country was founded, there have been hundreds of cases involving false imprisonment or unlawful arrest. Yet the proper due process argument is scarcely to be found among them. It is amazing that in 200 years of our country's history, so few have argued this most basic and important provision of constitutional law in defense of liberty in such cases. This failure to claim due process in arrest cases over this period of time certainly does not say much about those in the legal profession. The incompetency of most lawyers was expressed by Chief Justice Warren Burger when he stated that 9 out of 10 lawyers are incompetent. Most lawyers are not independent thinkers, instead they are nothing more than programmed robots who follow the path laid down by the prevailing system, whether it be just or corrupt. When it becomes corrupt, they will follow corrupt rules and statutes above fundamental law. This failure on the part of lawyers is especially remarkable when we consider the ancient existence of this due process guarantee, and that it is prominently found not only in our constitutions, but in Magna Carta, which proclaims, "No free man shall be taken or imprisoned or dispossessed, except by the legal judgment of his peers or by the law of the land." 60. The word taken has sometimes translated as seized and arrested. The phrase law of the land means the same as due process of law, and refers to the law already established in the land. Thus no one could be arrested except by the established common law that prevailed in the land. It does not mean some new law that the legislature might devise. The due process argument in false imprisonment cases will nullify the statutes, rules, and ordinances that are contrary to the common law rule on arrest. No legislative act can abrogate what is the law of the land, otherwise there is no such thing as due process. Government bass encroached upon the citizens' liberty by ignoring due process. The common law allowed arrests without warrant only for known felonies and breaches oft be peace. This is a required condition under due process of law in order to arrest someone. Thus it has been said that arrest without warrant, where a warrant is required, is not due process of law, an arbitrary or despotic power no man possesses under our system of government. Point 2. It should be quite obvious that if the legislature can say that arrests can be made without warrants for all misdemeanors committed in the presence of an officer, it can say that such arrests can be made when the misdemeanor is not in the presence of the officer. It also could say that such warrantless arrests can be made for mere suspicion, or because someone might break a law. All would be subject to summary arrests without question or warrant. One of the main reasons that a sword was put to King John to sign Magna Carta, and why the American colonists took up guns against King George III and his army, was to prevent the arbitrary acts of government in depriving people of their rights and liberties. Human nature as it is, such arbitrary action is the natural tendency of those having power in government, and without the due process provision, government is free to encroach upon the rights and liberties of citizens with immunity. The term due process of law had a well-settled meaning when the Constitution was adopted. The framers thereof intended to perpetuate and secure the many principles, laws, and rights, all of which could not be listed, against abrogation. Subsequent legislation cannot change the meaning or effect of this constitutional provision, and thus cannot change the procedure by which one is to be deprived of his liberty by way of arrest. An arrest cannot be done except by the law of the land, or due process of law. Fourth Amendment argument. Another reason for the distortion that Bass prevailed in the matter of arrests is the frequent misuse or misapplication of the Found Amendment in the U.S. Constitution, or similar provision in the state constitution, used as a defense to arrests without warrant. The Fourth Amendment, which guarantees the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, generally does not apply to arrests made without warrants, but only those made with. For more information on this principle of law, refer to Uft, Beauty and Property by the author. 2 Muslim v. Commonwealth, 86 Virginia 443, 10 SC 534, 536, 1890. Unts. The provision regulates how LLT3.NLS are to be issued. No warrant shall issue, but upon probable cause, supported by oath. 2. If an arrest was made with a warrant, must follow the criteria of the Fourth Amendment, otherwise it is an unlawful arrest, as the warrant would be illegal. But where here was no warrant, this provision is not applicable, rather we would apply the standards of due process of law. In one case in Illinois where a person was arrested without warrant pursuant to a statute, the person arrested questioned beta or the statute is in violation of the search and seizure section of the state constitution, similar to the Fourth Amendment. The state Supreme Court said. But this, Section L has application only to warrants. It does not abridge the right to arrest will warrant L in cases where such arrests could be lawfully made L common law before the adoption of IHE present CO Institution. Point 4. It is perhaps due to the ignorance of so many in the legal profession that we so often find this Fourth Amendment argument used as a defense against a warrantless arrest. The Fourth Amendment argument in cases involving arrests without warrant have been the most common defense raised, and the distortion in law it has created has been all too great. Due to this erroneous argument, the courts have developed the concept that any and all arrests are lawful as long as there was probable cause. But under the common law, unless bear is a felony. 61. Probable cause has no bearing on an arrest without warrant. Probable cause is to be a criteria in issuing warrants, but it now has been